And we are live. Yeah, in case anybody's watching already, we got time. We may as well just get ready now. So Darrell Brooks is going to be going forward with this. We'll see what's going to happen. I don't know how this is going to turn out for him. Let's just be real. It's well, I don't know if it can't go much worse than yesterday. I hope. um, so we will have to use long cuck, I think, for now. But we may be able to change that going forward. Share. So 17 people here. Yeah, guys. Sorry. Good afternoon, Matthew. So yeah, we'll see what happens. We will in the meantime, he did execute the forms the judge set up for him, and he did it by 9 a.m. So the court set the hearing as it promised. And yeah, we'll see we will see how smart little Darrell is today. Kim, this is not the trial. No. He is asking to represent himself in court. And at trial, he wants to represent himself. So the judge has to inquire of him, has to hold a hearing and determine, does he understand what's going on? Does he understand the rules he's going to be held to? And just to make sure he doesn't turn into a straight up lunatic. So that is part of the issue. You do have the right to represent yourself as long as you can competently, as long as you're competent and you understand what's going on. Because if you don't understand how this works, how things are supposed to go, well, representing yourself would turn into a mess. So we shall see what happens there. Will this move the next week's trial date? That maybe. I don't know. I'd like to think the judge might say, "Sorry, you've had time. Here we go." We'll see, because if she grants it, then that's the second issue. Hey, Robin, Debbie Lynn, Kim, AD, you're challenging. Hi, good luck on it, AD. Brandon, how you doing? Navy Vet 09. Darrell Brooks killed my mom's friend and injured my best friend's little sister. Let the bastard represent himself. Well, I have a feeling we're gonna get that wish. Parallax saying, I hope you learned to say I understand during the break. Yeah. Yeah, let's see if he did. Nope, they're still going, and I forgot to make that full screened. Oh, we can't yet. Oh well. This is Kim, you're asking, this is close to my house. Do you think it will be open to the public, the actual trial? Maybe, maybe not. You would be I would, if you have a couple of minutes, I would call down to your courthouse in Waukesha and ask them, is this going to be open to the public, or is it just going to be televised? It should be open to the public because, I mean, we're past COVID now. They're not like with COVID walls everywhere, but there might be an issue of seating. There might be an issue, sorry. Drink my drink down the wrong pipe. There might be an issue about seating. You may have to get there early, first come, first serve. These courtrooms may not be that big. This courtroom didn't look that big. There's going to be a lot of people in attendance. So I would just recommend you call ahead to find out what you're going to have to do, but you should be able to. A post-somatic IU. Howdy. Howdy to you too as well. Chris Kelly, super chat for £2 sterling. Thank you very much for your super chat. I appreciate your support. Watching live with popcorn in the UK. Love you, Sean. Well, thank you. I appreciate it. Is the self-driving car taking the stand? Hey, he has the right to remain silent just like anybody else. You know, maybe he will get up there and honk his way through it. But yes, that would be I wonder if that's going to be his defense at all. My favorite Ohio attorney. Glad I made it. Well, thank you. So, curious to know what you guys are thinking. And actually, here, we'll put up a poll. Everybody loves a good poll. Where is it at? We got to pull in. Yes, guys, we have a new Discord. Finally, I put one up. So come on in there and you can fill all your desires to spurg out and ask weird things and do weird stuff. So it's there for you. It's there. Everybody's welcome to join. If you'll remember, I will work something out though where we do some voice chats, things like that, where it's just you guys. But I wanted to, everybody can be in the Discord itself. Do you think Brooks will represent himself? Yes, no. All right, guys, there's a poll up, so we'll see what happens. We've got 5 more minutes, and it is still waiting. Just checked again, just to make sure. Oh, he released a letter. Hold on. We can look at this real quick. Where the hell is it? I'm trying to download this thing. Let me read it. Okay, you know what? We're just going to start watching this. Okay, Scribed, you suck so bad. Oh, I clicked Ask My Community. God damn you guys. Error occurred. Try again. Oh, fuck me. Yes, the eye wall of Ian's hitting Florida right now. If you're on the Florida coast, on the Gulf Coast, Godspeed to everybody. I mean, my parents are down there right now, and I'm the best for everyone. All right, fine. We'll try this again. Error occurred. Try again. Why can't I? Will not let me pull. It's saying errors. It keeps occurring. So I don't know what that's about. Maybe secretly I'm getting banned or something. I don't know. But while we have a minute, we're gonna look at what got filed today. So we'll bring this up and see what happened here. So this is from the Waukesha District Attorney's Office. Wow, they got a lot of district attorneys. So it's to Jennifer Dorow. She's the judge. The state requested convening on this hearing to discuss the defendant's request to self-represent. And they reviewed the record and they'd like to make more things known. Signed by from the prosecutor's office. Susan L. Opper, the district attorney. She's actually trying this case personally. Then this came in. Attention, Judge Dorow from, and then this is something that was sent into the court. Dear Judge Darrow, I'm not sure if this is right or proper, but I have to try anyway. My name is Dawn Woods. I'm sure you guessed the mutual. I'm sure you guessed the mother of Darrell Brooks. I'm writing you because I am worried because I am concerned about what happened in court today. I called Attorney Keys with my concerns regarding Darrell's mental state a month ago. I told them I believe he was becoming unstable, and I spoke to Darrell on a daily basis, and by our conversations, I could tell he was becoming unstable. Through he would always say he's okay. Being his mother, I could tell. I don't know if you're a mom, but moms always know when something's wrong. Don't Something's not right. I am counting. I encouraged him. I encouraged him to pray and read the scriptures. Hope that would help his issues here. I'm sorry, Trin, keep going. When I vowed my concerns to his attorneys, they just blew me off and just tried to be seriously at all. Did not take me seriously at all. I am now asking you to please do not let him represent himself. I tried to reason with him on Thursday when I spoke to him over the phone. He told me he doesn't feel comfortable with his attorneys and how they. Oh, we're going over the hearing. Actually, we got another minute. We'll try to blow through this real quick and see what else is there. So that's from his mom asking, okay, he's crazy. Wow, that's a lot of sheets of notebook paper, lady. Jeez. Yeah, and she just basically says she has concerns about his mental state. So let's switch back over. Share screen, Chrome tabs. Yes, here we go. I don't know about the volume, guys. I don't know how to fix it. Perfect timing. The judge is walking in. Ooh, the volume sounds better already.
Please be seated. Court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Your Honor. Sue Apper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Darrell Brooks appears in person with his attorneys, Anna Keys and Jeremy Perry. Good afternoon.
All right, good afternoon, everyone.
Object to that.
I'm sorry.
I'm here representing myself pro per.
All right, thank you, sir. Then we are here so that I can once again address the motion to withdraw that was filed by the defense attorneys in this case late last week. I did receive this morning a filing from the defense. It includes the waiver of right to attorney form that appears to have been signed by Mr. Brooks. I want to start with the defense team, because it's still a team right now, Attorney Perry, and I want to get some information from you for the record. So if you could please tell me how many times that you have met with Mr. Brooks since you've been appointed. I'm looking for you to quantify that for me if you can.
I need a moment.
Sure.
Finally, the poll's up, guys.
Your Honor, may I ask a question while they're reviewing that? Is the live stream on?
It is.
Okay. The monitors aren't on?
Not at the moment.
Okay, thank you.
I can confirm with them.
Okay, thank you.
You're welcome. Do you want the monitors on so you can
It's
see?
possible, yeah, it's a little easier for us to review Mr. Brooks.
Yeah, I don't know what we're doing right this second because what the hell, are they not ready?
Let me know when you have that.
Sweet Tooth, there wasn't a 9 a.m. hearing. His 9 a.m. was the deadline to file the paperwork he was supposed to file with the court. So he had to file his waivers by that time. So there was no hearing this morning.
Not sure that I can.
Okay,
While they're looking through their notes, if you would confirm that you've complied with victim rights.
yes, thank you, we have.
Thank you.
Thank you, Your Honor. We can say we've met with him at least 25 times.
Thank you. In your meetings with him, have you reviewed the charges that he faces and the penalties and exposure?
Yes.
Have you discussed with him the nature of the charges?
Yes.
Have you provided Mr. Brooks with any of the pleadings that have been filed in this case?
Yes.
Anything that you have not provided him, perhaps by maybe not the jury questionnaires, but things in this case, anything that's not confidential?
Everything has been communicated.
We're switching over to the Wisconsin court thing. It's a little louder.
Terms of reviewing videos. Not all electronic discovery has been reviewed. There are lots of audio files, but I should say reviewed with Mr. Brooks at the jail.
Thank you. Have you communicated with Mr. Brooks during the course of your representation in writing, either you to him or him to you? I'm not looking for you to divulge any, privileged information, just generally, how have you communicated with him?
There's been sometimes in writing.
Has he written to you at all?
Yes.
Have you had any concerns with his ability to communicate with you either orally or in writing at any point in time during your representation?
I want to answer the court directly, but I'd like to answer this way, is that, and maybe this is not what you're asking, but we are very aware of our obligations in terms of raising any concerns if there were about competency or the ability to communicate. And
I'm not looking
you're
for
not-
that.
you're not
No, I'm
inquiring.
looking more for your assessment of his literacy and his ability just generally to communicate with you in the English language.
We've not had any problem communicating with Brooks.
I'll have to go back to law and crime to do closed captioning, guys. Sorry. We'll go
My
back.
understanding that he provided to you or to Attorney Keys the waiver of right to attorney form that he filed with the court this morning. Is that true?
That was delivered to us.
Thank you. It's my understanding that he provided to you or to Attorney Keys the waiver of right to attorney form that he filed with the court this morning. Is that true?
That was delivered to us via by jail staff this morning.
Thank you. I know that you also filed a case, really a summary of that case with the court. Is there anything you want to put on the record at this hearing regarding that filing?
Only that I think from some of the comments of Mr. Brooks, and I say this with the understanding that, you know, we view him, of course, our motion to withdraw has not been granted. We're still representing him, and it is our clear understanding that it is Mr. Brooks's desire and objective to represent himself in this matter. There are some things at yesterday's hearing that I think maybe seemed inconsistent with that in terms of colloquy with him, and some things that perhaps appeared inconsistent on his written waiver of attorney form. We provided that case law in that context of United States v. Banks with the exchange that has some real similarities to the exchange that happened in court yesterday, where, and this is, you know, if there's a distinction being made in the sense of what part of the Sixth Amendment does Mr. Brooks wish to waive in terms of how he sees himself as appearing in this case as a special appearance, pro per, as he has said, that the context of that with his
He's in the orange right there.
quite clear statements throughout yesterday's hearing of where I think he said multiple times that his wish is to represent himself in this matter. We provided that to try and place some of the sovereign citizen language in context where it is maybe not as inconsistent as it may first seem, to support what Mr. Brooks is saying he wants, and that is to represent himself in this matter.
What I hear you saying is that certainly prior to yesterday's hearing, Mr. Brooks made it very clear to you he wants to represent himself.
That's right. That's why we filed the motion to withdraw.
Has he done or said anything to you that would cause you to change your assessment of his desire?
No.
Thank you.
There is one additional thing from yesterday's hearing that I think I should add to the record.
Go ahead.
There was a lot of back and forth with Mr. Brooks, and you know, it's been reported on in terms of his, and even the way he filled out that form where he crossed off the word understand. And I think on the form he wrote, "I'm informed of that." And yesterday in the hearing, repeatedly clarified when asked if he understood things, said I'm aware of. In rereading Ferretta and Imani v. Pollard and the case law on this, it actually requires, the case law requires, and maybe this is all just semantics, but the language in the case law requires that the defendant be made aware of the charges and the penalties and the risks and disadvantages of proceeding by representing himself. And so I just thought I should mention that to the court in terms of what the language of what the case law actually requires is.
Thank you. I would not disagree with your assessment of Ferretta and Imani. Of course, we have a form in Wisconsin that has been approved by the State Forms Committee of the Director of State Courts Office and Court Ops, and there is some specific verbiage that is on there, which in the vast majority of cases, I think, satisfies the parties. But I clearly understand what you're saying, and I don't disagree, but I do thank you for bringing that to my attention. Mr. Brooks, I do have in front of me a waiver of right to attorney form that was electronically filed into the case today. I'm going to pull it up. You acknowledge, sir, that it is before you on the screen.
Yeah, I can see it.
I don't want to make any assumptions, sir, about who filled out this form and how it got to me, so I'd like to ask a few questions about it. I, of course, gave you this form at the end of yesterday's hearing. Hold on a second, that's the live stream, it's the feedback we get because I'm displaying my computer, so give me a second.
Pretty much.
I'll do it a different way.
No, they don't get to quit. What? Uh-oh. Judge just... Oh, there we go.
Yeah, no, I have his original copy that I could place in front of him.
Should also be on the share screen. Are you able to see it in front of you as well, or no?
Not at the moment.
I did a test with this yesterday to see if I shared my screen, how it would come up on the live stream, and I thought it was working, but it's all right. I'll stop the share screen.
Hmm.
Mr. Brooks, if you want to confirm with me that your attorney has put in front of you the original.
Excuse me, say it again.
Sure, could you please confirm that your attorney placed in front of you the original waiver of right to attorney form that you filled out?
Yes, right.
You acknowledge, sir, that I provided this form to you at the end of the hearing yesterday.
Yeah, I'm getting this.
I filled in certain information on this form regarding the caption at the top. That's the part that's typed. You acknowledge that.
Which part are you referring to?
So the very top of the form is a caption where it says State of Wisconsin versus Darrell Brooks, and there's typewritten information. I'm telling you, I filled that out. You would agree with that.
I didn't see you fill it out.
Sir, when I gave you the form, was that portion of the form filled out with typewritten information?
Yeah,
All right. There's a section further down that says crimes and penalties. Do you see that?
yeah, I see it.
When I gave you this form yesterday, was that section or both of those sections actually filled out with typewritten information?
Yeah,
And that's the information that's on the form in front of you. Is that correct?
yeah.
If you turn to the second page of that document, there's a signature box that has a number of lines. Do you see that?
Yeah,
And there is one line where it says name printed or typed with the name Darrell E. Brooks typed in. Do you see that?
I see it, but that is not the way my name is. I
Sir,
don't acknowledge
do you
that name.
acknowledge, just listen to me, sir. Do you acknowledge that when you received the form,
Bruh.
that printed name was on it?
I recognize that there is a name printed on it.
Brew.
It's not mine.
Come on.
Sir, the form that you have in front of you, which has a lot of other information on it, did you fill that out?
I filled it out a certain type of way.
Listen to me, sir. Did you provide the handwritten information on this form?
Yes,
I want to confirm the information that you filled out. My understanding, you are 40 years of age, is that correct?
yep,
It's also my understanding that you completed 11 years of schooling, is that correct?
yep.
You have either a GED or an HSED, is that correct?
Yes,
Do you know which one?
the HSCD. I
Thank-
said that yesterday.
Right, I've read in other materials that it was a GED, that's why I'm asking you.
I clarified it yesterday that it was the HSCD.
Thank you. It's also my understanding that you are able to read, write, and use the English language. Is that correct?
Yes,
English, as I understand it, is your first and only language. Is that true?
yes,
Further, my understanding, sir, that you are not currently receiving treatment for a mental or emotional problem. Is that true?
not currently,
Is that true?
not currently.
Did you hear my question?
Yeah, I heard it.
Is it true that you are not currently receiving treatment for a mental or emotional
No.
problem?
No,
It's not true.
say it again.
Is it true that you are not currently receiving treatment for a mental or emotional problem?
Yeah, that's true.
You also have checked that in the past, you have received treatment for mental or emotional problems. Is that true?
Yes,
Further, my understanding, sir, that you have not had any alcohol, medications, or drugs within the last 24 hours. Is that true?
yes,
It's also my understanding, based upon how this form was filled out, that you do not have any physical or psychological disability that may affect your ability to be informed what is happening in court or communicate your position or views on the case to the court. Is that true?
yes,
We talked a little bit about this yesterday. You graduated with an HSED, as we talked about, right?
Yeah.
You've been able to read the various documents that have been provided to you in this case. Is that true?
yeah,
You're able to write. Is that correct?
I can't boost the audio, guys.
Let's go down to the next section, sir, where it says, I am informed that I have been charged with the following crimes that carry the following penalties. Do you see that section?
yeah,
I want to advise you of the following. I want you to listen to me. You are charged with 6 counts of first-degree intentional homicide, use of a dangerous weapon. Each one of these counts is a Class A felony, punishable by life in prison, plus an additional 5 years for each count. Are you aware of that, sir?
I am informed, yes,
You are also charged with 61 counts of first-degree recklessly endangering safety. Each one of these offenses is a Class F felony, imprisonment of not more than 12.5 years plus 5 years for the enhancer for use of a dangerous weapon for each count if convicted. And you are aware of that, sir.
yes, I'm informed of that, yes,
There are also 6 counts of hit and run resulting in death. These are Class D felonies. Imprisonment of not more than 25 years for each count. And you are aware of that as well.
I am informed, yes. I was under the impression that it was a certain type of way in the wording.
Sir, you are also charged with 2 counts of felony bail jumping. These are Class H felonies. And upon conviction, you may be imprisoned for not more than 6 years for each count. Are you aware of that?
I am informed,
And then there are 2 counts of misdemeanor battery. Those are Class A misdemeanors, and upon conviction, you may be imprisoned for not more than 9 months. Are you aware of that?
I am informed,
Have you been informed, sir, regarding the total exposure if convicted of all counts as charged across these 77 counts?
I am informed, yes.
Are you informed, sir, that as to the intentional homicide charges, use of a dangerous weapon, that if convicted, you could be sentenced to 6 life sentences consecutive to one another?
I'm informed.
Do you understand? Strike that. Are you informed, sir, that you could be sentenced consecutively on each one of the counts for which you are convicted?
I'm informed.
For the first-degree reckless and endangering safety charges, without even the enhancer, are you informed that the maximum exposure is 762 and a half years?
I'm informed.
Are you informed that when adding the enhancer, it adds an additional 305 years?
I'm informed.
You informed that the hit and run resulting in death charges carry an exposure of 150 years.
I'm informed.
Are you informed that the felony bail jumpings carry an exposure of 12 years?
I'm
Are you informed, sir, that the exposure for the 2 Class A misdemeanors is 18 months?
informed.
You informed, sir, that all of the charges stem from an incident that is alleged to have occurred on November 21 of 2021 in the city of Waukesha.
I don't see that on the sheet.
Sir, did you hear what I said?
I thought I was following the sheet. That's why I'm looking. at
Sir,
the sheet.
did you hear what I said?
Oh, I did not hear what you said.
Sir, are you informed that all of the charges stemmed from conduct that is alleged to have been committed by you on November 21 of 2021 in the city of Waukesha?
I'm informed.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha Parade incident? I don't know who they is, and I don't frankly care. Listen to my question, sir. Did you hear what I just asked you?
No, I'm not informed of that because it's never been referred to.
Sir,
Still not
I am
understanding.
advising you that your conduct that is spelled out in the second amended criminal complaint, which this court provided you with yesterday, accuses you of committing multiple offenses
Is this better? Tell me if you guys can hear this.
during the Waukesha Christmas parade. Did you hear me say that?
Yeah, I just heard. Thank you for correcting the language.
The next part of the form, sir, and I will return to it, is entitled, I understand I have the right to. Do you see that?
Mine says I am informed.
Sir, the form, listen to my question. Do you see the section of the form that is entitled, I understand I have the right to?
Mine says I am informed.
You're not listening to me, sir. I'll get to that. But the form, the state form, has a section that is titled, I understand I have the right to. Do you see that?
Yeah, I see it.
All right, you changed the word I understand to I am informed. Is that true?
Yes.
I'm going to advise you of the following. I want you to just listen. Sir, you have the right to have an attorney represent you at all stages of the proceedings. You have the right to have an attorney appointed for you by the state public defender if you do not have the money to hire an attorney. You have the right to hire your own attorney at your own expense. You have the right to ask the court to review a determination by the state public defender that you are not indigent and able to hire your own attorney. You also have the right to ask the court to find you indigent or partially indigent and appoint a court-appointed attorney for you at county expense if you have been found not eligible for a public defender. You also have the right to represent yourself and act as your own attorney. Did you hear me just now, sir? There is a line underneath those advisements that says, check this box if you read and understand the above. On the form that I have, the word understand is changed to am informed of. Is that true?
Yes,
The box is checked. Is that also true?
yes,
Did you check this box?
yes,
The next section of this form is titled, I understand an attorney would. However, on the form that I have, the word understand is changed to am informed. Do you see this section of the form, sir?
yep,
Did you change the word understand to am informed?
yes, I did.
I'm going to advise you of the following. I want you to just listen. You are advised that an attorney would represent you and speak on your behalf in court. An attorney would also advise you about your legal rights and options. An attorney would explain and assist you with legal and court procedures. An attorney would help you negotiate a settlement of your case with the district attorney. An attorney would investigate and explore possible defenses to the charges against you that may or may not be readily apparent to you. An attorney would prepare and conduct a defense on your behalf at any motion hearing or trial. An attorney would file motions on issues of evidence, testimony, and procedures of the police. An attorney would assist you at sentencing if you are convicted of any crime. An attorney would also file an appeal if requested. Did you hear me just now, sir?
Yeah, I heard
On the form that I have, there is a line underneath that says, check this box if you have read and understand the above. The word understand has been crossed out and changed to am informed of. Do you see that?
you. Yep,
The box is not checked. Do you see that?
yep.
Was that an oversight?
No, it's a reason.
I'm sorry, I didn't understand what you just said.
There is a reason.
Do you sir, I advised you of what an attorney would do. Are you informed of what an attorney would do for you?
Yes,
Why did you not check this box?
because it is my understanding that representing myself pro per, I can have standby counsel. So that in a sense is why that box specifically is not checked.
That is not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court.
Either way, it's still allowed for me to have.
Have you been advised, sir, that the public defender's office is not able to perform standby counsel duties?
No, I have not been advised that.
There is a rule that was promulgated by the Public Defender Board in Wisconsin that prohibits public defenders from acting in the capacity of standby counsel. Did you hear me advise you of that just now?
Yeah, I heard you say it. What is it called?
You referenced standby counsel, sir. I'm advising you that the Public Defender's Office is not able to act in that capacity. Did you hear what I just said?
I heard what you just said.
That's
I
interesting.
asked you a question, is that somewhere that I can
Very interesting.
find out about that information? Some type of law or some type of,
That sounds like it's their interpretation of the
though.
rules. Oh, he's trying to bitch out. He wants backup. He wants standby counsel. He's not going to do it on his own.
We're gonna get a bit of feedback, but I'm gonna put it up on my screen, which the parties will be able to see.
Speak softly like this. It's very interesting. He's been going on and on about representing himself, but he wants standby counsel, which tells me he's not necessarily going to do this whole thing by himself. That he's gonna
Sir,
back
can
out.
you see what's before you?
Oh, I'm
on the
coming in hot.
screen?
Hold on.
Yep,
This is an administrative
There, I put
code
it down better.
provision, chapter PD 5, adversary representation. I direct your attention to PD 5.03, prohibition against acting as standby counsel. Sub 1, no SPD attorney may act as standby counsel in
Yes,
any
he can
case.
stop.
Sub 2, this prohibition applies whether or not the SPD attorney was originally providing adversary representation in this case. You see that, sir?
yeah, I see it.
I'm gonna take that down. This court, sir, you should be advised, would not be appointing attorneys Perry and Keys to represent you or to act, is a better way of saying it, as standby counsel in this case. Did you hear what I said?
Yes, and I didn't ask that. I didn't ask for them.
Not asking if you asked that, sir. I'm giving you advisements right now that you need to listen to. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
This court is further advising you, sir, that this trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that. And I object on the grounds that, are you making a judicial determination of that when you haven't even decided the issue while we're here?
Sir, I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58. This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Checking. Is this better, guys?
Sir, did you hear me just now?
Is that an answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a rush to
Mr. Brooks,
judgment.
we'll move on. You are advised
You are
that,
rushing to judgment.
Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said that.
There
but
are
you
a
didn't
number
answer
of reasons which I will advise you make it impractical.
You're not
This
answering
trial
my
is
question, though,
scheduled.
Your Honor.
Mr. Brooks, do not interrupt.
That is a rush to
Mr.
judgment
Brooks.
if you don't answer the question. That's
So
a
we
rush
are
to judgment.
here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
Ha!
That's
I'm just
not
merely- I'm
relevant,
just
sir.
merely
The motion is
asking-
before
I'm
me
just
and I'm
merely
going
asking-
to address it.
I'm
Stop
just merely
talking
asking
over
the
me,
question.
Mr.
That's
Brooks.
it. Just merely asking
I
the
need to
question.
get through the advisement.
And I would like to know the answer to the question that
You are
I'm
being
asking.
difficult. You are not listening.
Bruh.
You are
Bruh.
trying to interject irrelevant factors for this court.
It has
So,
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able to
going
ask
to
questions.
continue. Please stop talking.
So it is a rush to judgment.
Mr. Brooks,
So much to judgment. What up,
the
cool
case
frog?
law makes very clear you can't waive your right to an attorney. Let me rephrase that. The case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation
Hey,
while
baby.
simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today. The next section of this form is entitled, I understand that if I represent myself, but on my copy, the copy e-filed in this case, it says, I am informed that if I represent myself. Do you see that section, sir?
What section are you referring to?
The section that is labeled, I understand that if I represent myself, but the word understand has been changed to am informed. It's on page 2.
His papers got shuffled up.
Not a death penalty case,
Let me
no.
know when he has the correct page in front of him.
Why isn't his lawyer telling him to shut up? Because he's trying to represent himself. So at this point,
he's got
he's
it.
there to talk.
Thank you. Do you see
On
that
his own.
section, sir?
Now, what section were you referring to?
The section that says, I understand that if I represent myself, but the word understand is scratched out and it now reads, I am informed that if I represent myself. It's on page 2. Do you see that?
Yes, I do.
You are advised, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice. You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard it.
You are further advised, sir, that acting as your own attorney may be very challenging. You would be required to participate in jury selection, including exercising preemptory strikes. It may be difficult for you to raise the issue of strikes for cause. At trial, it may be difficult for you to raise objections, both when to make them and how to make them, whether it be as it relates to the admission of evidence or the testimony of witnesses. Other obstacles that you will face include applying the rules of evidence, understanding and applying the rules of trial procedure. These are things that are spelled out in the Wisconsin statutes. They're the law. You may face challenges when it comes to jury instructions, including when or whether to ask for jury instructions on lesser included offenses. Did you hear me advise you of these challenges, sir?
I did hear you advise me of them. I don't see them as challenges, Your Honor. At all.
The court must also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
I like to live dangerously.
You may even find, sir, that if I allow you and honor your request to represent yourself, that once this trial starts, you may find it difficult and may even express a desire to change your mind. In other words, you may regret the decision that you make. I'm advising you, sir, that at that point, it would be challenging for this court to reinstate your right to an attorney. Did you hear me advise you of that, sir? Did you hear me, sir? Mr. Brooks, did you hear me?
Yeah, I heard you.
Once,
Can I ask why would it be challenging?
sir, let me continue. I want to advise you the following. When a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
The case law says that rescinding a waiver of an attorney is no different than a motion seeking the substitution of an attorney. That is why this court is advising you it would be challenging for this court. I didn't say impossible, it would be challenging. There is significant case law on substitution of counsel and it falling within the discretion of the court. There's criteria discussed in cases such as State versus Lomax, State versus Boyd. There is case law that discuss 11th hour requests, which are generally frowned upon as delay tactics. The court would consider things like the impact on the court's general responsibilities for the prudent administration of justice. The court would consider whether requests like that interfere with the administration of justice, the impact to the court's docket in general, and other considerations, including the significant amount of time, resources, preparation that the court, the parties, even the clerk of court and the sheriff's department have put together to bring this case to trial in October of this year. Did you hear me advise you of all of these things, sir?
Yes.
There's a reason I'm telling you, sir, about some of these challenges and difficulties, and that is because I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself pro per. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself pro per had nothing to do with a delay tactic. I think I'm very
So-
clear with what I said.
Well, I want to be clear, I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that
That's-
true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
Just
I heard
answer
you say
that
that.
question.
And I
Knowing
still
that,
can't
sir,
logically, I still can't logically answer what you are asking me because a decision has not been reached.
sir, what you need to understand is that the case law makes it very clear you have the absolute right to represent yourself. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I know that.
You have the absolute right to have an attorney represent you. That is protected by the US and the Wisconsin Constitutions. Did you hear me say that?
I'm aware of that as well.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir.
Yeah,
You
what
have the right to an attorney.
the fuck is he
You
going
have
on
the
about?
right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand. Sir, you have raised a phrase throughout the last 2 days that has very specific meaning to this court, and I believe to you as well. You have used the phrase in pro per. That is a shorthand way of saying in propria persona. That comes from the Latin phrase, which means in one's own proper person, also referred to as pro per or pro se. I presume that when you use that word, you are doing so intentionally. I told you the Latin phrase that it comes from, or the meaning. In a court of law, it has a specific
She's throwing it
meaning.
right back at him.
And it is used when a person represents himself or herself without a lawyer, meaning without the assistance of counsel, without the assistance of an attorney. When you use that word, sir, it is no different from the phrase pro se. The use of that phrase by you, sir, is a clear indication to this court that you want to represent yourself without the assistance of an attorney. Did you hear me advise you of this just now, sir?
Yes, and I'm aware of that same definition by the Black's Law Dictionary.
Oh, no, bro. Don't do that.
Let's go back to the form, sir. We went through this section about what it would mean to represent yourself and what a judge cannot do, what a DA can't do. And then I further went over many of the challenges and obstacles you would face. Underneath the various statements on this form, there's a statement that on the form reads, check this box if you have read and understand the above. On the form that's been submitted to the court, it reads, check this box if you have read and am informed of the above. Do you see that?
Yeah, I see it.
The box has a check mark. Did you place that there, sir?
Yes, I did.
Sir, it appears to me that you read through this form very carefully. Is that true?
Yes,
You clearly changed words on the form, right?
yes, for a reason.
It appears to me you did not have any difficulty reading the form and being aware of the contents. Is that also true?
It's true to an extent where I put, please elaborate first on one of them. That was the only thing that I had a question of.
Sir, I cannot give you legal advice. What I can tell you is you are required, if you represent yourself, to follow the rules of evidence, the rules of procedure that are spelled out in the Wisconsin statutes, no differently than if
And
you were an attorney.
if I was a licensed attorney, which I'm not, which means that that would be pro se and not pro per.
Sir, they mean the same thing. I don't frankly
Oh, for the
care
love of
what you
Jesus.
call them. The terminology you
Not the same
use
thing.
has the same effect. You either have an attorney or you do not. Did you hear me say that?
I'm aware of that.
Underneath that last checkbox, there is a paragraph that reads as follows. I am making this decision to represent myself knowingly and voluntarily. No one has made any promises or threats to me, and no one has used any influence, pressure, or force of any kind to get me to not ask for an attorney. No one has told me I should not ask for an attorney to represent me. Do you see that?
Where it says I am informed of the court process involved in my case, that part. The top part. Yeah, I see
Underneath
it.
the last checkbox that we went
See it,
through,
I see it.
you see it?
Yep.
Remember reading it?
Yeah, I see it.
There's another paragraph, and it appears to me that you read it and that you changed the word understand to am informed of or on. Do you see that?
Yep.
Says, I have
Oh my
read
God.
or have had read to me this entire document. I've truthfully answered and am informed on all portions of this document. I'm informed of the court process involved in my case so that I can adequately represent myself. I want to represent myself There's a
He's
handwritten
not talking
notation, I
about for
do
the
not
record.
give up my right to assistance of counsel, will explain reason, all rights reserved, and there's a signature. Do you see all of that, sir?
Yes,
You signed this document, sir?
in my true name, yes.
Sir, anyone make any threats or force you in any way to sign this document?
No,
Anyone make any promises to you in exchange for signing this document?
no.
245 people watching. Thank you so much. Guys, please give me a like if you enjoy this.
You understand, sir, that by signing this document and presenting it to the court, you're asking me to accept your waiver of the right to an attorney.
Just so I'm clear, that would be essentially just that part of my Sixth Amendment, correct?
Oh my God.
The right to an attorney, yes.
Holy
Just
Jesus.
that part.
We are just talking about the right to an attorney, sir.
So essentially, the rest of my Sixth Amendment right is preserved.
That is correct.
Thank you for clarification.
Sir, do you wish to waive your right to an attorney?
Yes,
Anyone make any threats or force you in any way to waive your right to an attorney?
no,
Anyone make any promises to you in exchange for you waiving your right to an attorney?
no,
You understand, sir, that means attorneys Keys and Attorney Perry will be discharged from this case.
I'm informed, yes,
You are aware that means they will be discharged from representing you.
yes,
You are aware they will not join you at that table after that decision is
I
made.
am informed, yes,
Do you believe you are making the decision to represent yourself knowingly and voluntarily?
yes,
Do you believe you are fully informed about the advantages of having an attorney represent you?
repeat that again.
Do you believe you are fully informed about the advantages of having an attorney, someone licensed to practice law in the state of Wisconsin, represent you?
Fully informed, yes,
Do you believe you are fully informed of the disadvantages and challenges of representing yourself and acting as your own attorney?
yes, I am informed.
Cool Frog, thank you for your
went
membership. I
through this
appreciate it.
A little bit, sir. And while I know you have not asked for an adjournment, I want to make a few things clear if I haven't already. This court feels compelled to advise you
Thank you, Kim. We'll get to it in a
in
second.
advance of a final determination by the court that this trial needs to take place in October of 2022 due to significant steps to secure a jury. This includes the extra jury pool. By that, I mean initially summonsing approximately 1,600 qualified jurors, setting out what we call the initial qualification questionnaire, followed by a case-specific jury questionnaire sent to the vast majority of those 1,600 individuals. In addition, this trial was scheduled 6 months and 22 days. Will be 6 months and 22 days on October 3rd, roughly 6.5 months. It was scheduled on March 11th. We've had significant litigation to date, including a motion to change venue, a motion to adjourn. We've conducted significant hearings regarding the jury selection process. This court heard and decided a motion limiting other acts. This court dismissed 6 counts upon the motion of your attorneys. This court set aside 1 month in October of this year to try this case. The Sheriff's Department has set aside this time. There's extra personnel that's been required from the clerk of court's office, the Sheriff's Department, just due to the high publicity of the case, the number of people involved, etc. Did you hear me advise you of this?
Yes.
Knowing all of this, is it still your desire to waive your right to an attorney?
Yes.
Attorney Perry, anything you want to add to what I've questioned Mr. Brooks on at this time, or any other information you think I should know?
We will promptly give Mr. Brooks preparations that we've done for trial. We'll have delivered to him, and I understand that the jail is going to be working to make electronic discovery reviewable for him and taking all those steps.
From the state, anything you'd want to add to the record at this point, Attorney Opper?
Yes, Your Honor, thank you. There's a couple of points, please, if you could indulge me here for a minute. The court has certainly been very thorough. There's just a few things that I would like that you could perhaps drill down on just a tad bit more. My concern is on the form that you've just spent extensive time going through with Mr. Brooks. There's indication at the very, very top of it, and again, in the middle part, suggesting that Mr. Brooks has the right to an attorney at any time of the proceedings or any time during the proceedings. You have been very clear here with him that that's not absolute. So I just would like him to be advised that he can't flip-flop. He can't get into the trial and decide on day one he wants a lawyer and then change his mind back and change his mind back again. I think he should be advised of that, because the form does say I may change my mind at any time on the second sentence of the form. And that needs to be made abundantly clear to Mr. Brooks that that's, I believe this form is used largely in the pre-trial capacity and not the week before trial. So I would like the court to please advise him of that. Do you want to do these one at a time, or do you want me to?
Sure, I think that's
Okay.
a good idea. Mr. Brooks, did you hear the state's concern as voiced by Attorney Opper just now?
I think you were pretty clear in what you advised me of. I think you made it very clear that it would be challenging, but not impossible. That was your exact words, verbatim. So what needs to be made abundantly clear when you've already done that?
Thank you, Mr. Brooks. One of the challenges of being judge is I can't give advisory opinions, right? I can't give advice, but in the context of waiving your right to an attorney, I think it's important that you understand exactly what Attorney Opper has just said, and that is this form is generally used in the pretrial context, not at the 11th hour on the verge of a trial starting. You are correct. It's not impossible. It's incredibly challenging. I told you a couple of the cases that I would need to consider. But what I would further tell you and advise you is that the right to an attorney is not absolute, and that's from the case law. Once waived, the Sixth Amendment right to counsel is no longer absolute. And I'm looking at the Wisconsin case of State versus Rhodes, citing to United States versus Salina, and other cases from various circuits. That was a Seventh Circuit case, but Menfield versus Borg, Brown versus Wainwright, Merchant, United States v. West. Those are all cases that are cited by Rhodes. And I referenced State versus Lomax. There's also State versus Lovetto. And these are some of the considerations that,
No, they're
that I
not.
would need
I
to
don't
consider
believe.
if it were raised, and that includes practical concerns of
No,
managing
death
its
penalty
docket. That's my
does not
concern.
exist in Wisconsin.
Impact that a request may have on its general responsibilities for the prudent administration of justice, the timeliness of the request for substitution of counsel. All of these cases are substitution of counsel cases, but the case law makes clear that when a pro se person seeks to now,
Okay.
however you want to call it, sir, in pro per person wants to request an attorney, I treat that as a request for substitution of counsel because you're acting as your own attorney. I think you understand that because we've discussed it, you've acknowledged it, but did you hear all of the advisements just now?
I heard the advice.
Any questions for me about that?
No.
All right, Attorney Opper, the next.
Also, I think you have made it abundantly clear, but you touched on the idea of co-counsel or hybrid counsel, that obviously, once he's allowed to self-represent, there will literally be no one sitting next to him, not as if he can ask some questions and another attorney sitting next to him can ask some questions, or they can share responsibilities or duties.
Thank you. Mr. Brooks, did you hear what the state just said just now?
I heard it, and again, I think, like was just stated, you were abundantly clear on that issue as well.
We talked some yesterday about some of the challenges. You would agree with that?
As far as it.
Representing yourself. And I'll be a little more specific. Yesterday, I went through the experience of not only your own attorneys, but the experience and the resources available to the state. Do you remember that?
I do.
I may not have said it this way, but one of the things the state will be able to do is there are 3 attorneys seated at that table. They can divide and conquer the work between them. Did you hear what I said?
Yes, ma'am.
You're fully informed about that, correct? And I'm going to just, I know you don't like this word, but you understand you're going to be sitting at that table by yourself, right?
I'm not alone, I don't think.
There will be no attorney seated next
No,
to you,
I know
correct?
what you mean. I know what you mean.
All right. You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that.
I am informed.
Any questions regarding that?
Not at all.
All right, Attorney Opper, your next point.
Thank you. On the second page of the form, you did touch on him under the section that reads on the form. I understand that if I represent myself on the 5th bullet, he wrote in there, please elaborate first. I believe you did elaborate on that and further told him that you're not allowed to provide legal advice to him, but I didn't know if there was a specific question that Mr. Brooks had that perhaps the court could address, perhaps not, if it hinges on legal advice. But
Fair
it was a little bit ambiguous what he wrote there.
Fair enough, sir. You obviously wrote some things on this form. Do you have any questions for the court at this time regarding this form?
I think you touched on it a little bit, on what the question would have been. And that was basically just, the stressing that I did of the pro se thing. Because essentially, from my understanding, is that pro se, in a sense, because I would be basically like I'm a licensed attorney. So that would kind of limit what I'm able to do versus being pro per.
Oh, no, stop.
You touched on it a little bit and gave me a little
Sir,
bit
I'll
more
tell
clarity.
you, it doesn't matter what you refer to yourself as, whether it's pro se, pro per, in Priya persona, you will be acting as your own attorney. And I believe you fully understand that. I want to go back to the box that you did not check.
What a
though.
maroon.
Given everything that we've discussed here today, do you have any questions regarding the section regarding what an attorney would do on your behalf? And I don't mean you acting as an attorney, but a licensed attorney in the state of Wisconsin assigned to represent you.
Yeah, you touched on it. I think it came up like right when I had voiced that and you kind of clarified it.
Understanding that this section refers to a licensed attorney in the state of Wisconsin, would you be willing to check this box now? That you have read this section and that you are informed of the above.
Yeah, I'll check.
You have the original. I'm going to ask that
So he's gonna do it.
if you're willing to do that, that you do that, initial it, and date it.
Quick question on that. What is the significance of the initials and date? Is as it pertains to
For me,
not having to do that for the I think you know what I'm saying.
for me, the form that I have was signed yesterday, the
'Cause you already
27th,
signed it.
today's the 28th. It's an indication anyone reviewing it later would know that that was added at a different date.
Okay,
It preserves the record from my perspective.
gotcha.
All right.
Your attorneys could tell you, but you don't want them to help. So yeah, he's gonna do it. Now you guys are wondering why his attorneys are still there, because he hasn't officially been allowed to proceed on his own yet. His attorneys have not had the chance. They have not been officially discharged and allowed to withdraw. So until that happens and the judge officially says you are excused from any further action, they're still there. They still have to sit at the table. So technically, he could revoke it still. He
The
could still
record should
revoke
now
it right now.
reflect I do have the original, which actually is a little bit easier to read than the scanned version. And Mr. Brooks did check the box that was
She
originally
can
left
still deny it.
unchecked. There appears to be 3 initials and then today's date. Thank you. Attorney Opper, your next point.
Last point does relate to the form, and it goes hand in hand with what just occurred. At the bottom of the form, it states in all bold letters, this form shall not be modified. It may be supplemented with additional material. I think that's standard printing on the form, but I just want Mr. Brooks to be aware that obviously you are accepting the form as modified by him at his request, so that there's no question later that you accepted the form contrary to the printing on the form that says it should not be modified.
Thank you for bringing that up as well. I certainly understand that. Mr. Brooks, you would agree any of the changes that were made by you and not this court.
Yeah, I mean, I feel like we've covered everything dealing with that form. I don't.
Because they know you're going to try to worm your way out of it later.
Relevancy of stressing the form that we just spent so much time going over. I think you were more than clear in your advisements of exactly what the form meant. And I think you were pretty clear.
Thank you. Is that it, Attorney Opper?
That's it to the form. I would request an opportunity to be heard on the motion prior to ruling, or if you're going to defer ruling.
No, I am going to rule. I will certainly give you an opportunity to make any statements you want
In her best Wisconsin accent.
before I issue a final decision. So go ahead.
The only outstanding issue, Your Honor, we have not
Outstanding.
yet spoken of it today on the record, was the letter that was filed by the defendant's mother. I believe it came in late yesterday afternoon or first thing this morning.
We covered that right
In
before.
which she has indicated she thinks Mr. Brooks is not competent to be making these decisions. I just wanted the record to reflect that we've reviewed the history of offenses for Mr. Brooks in the state of Wisconsin. We know he has a record outside the state of Wisconsin, but we have not been able to develop that. First, the record should reflect that he is experienced in the criminal justice system. He has been charged
He is
and
experienced.
convicted and sentenced for prior felony offenses. He's been through the court system on at least 10 prior occasions, or 10 prior cases, I should say, in the state of Wisconsin. The majority coming from Milwaukee County, one from Wood County, one from Manitowoc County. We could not find on any occasion, searching court records available online, a situation where Mr. Brooks had competency was ever raised, or he had claimed himself to be incompetent, or counsel or the court had ordered an evaluation for competency. It's never been an issue in any of his 10 prior cases. We're also aware of the Ngi evaluations that were performed in this case. It's certainly a different issue, competency versus insanity, but they were all licensed professionals, psychologists and psychiatrists, in my professional opinion, would have alerted the court if in the course of their Ngi evaluation, they thought there was concern as to the competency of Mr. Brooks.
I bet she has
That
Packer
did not
season
occur
tickets.
as well. Lastly, I would
Good old Sue.
note, and Attorney Perry touched on this at the beginning, he started
Suzanne.
to touch on it, that Attorneys Perry and Keyes apparently have never felt that competency was an issue or needed to be addressed by this court. It has not been raised by them. The court record here is clear. I've been at every court appearance. I have never had any concerns of Mr. Brooks' competency. He appears
Competency.
to me to be intelligent. He appears to fully understand what's going on in these court proceedings. He has the ability to communicate efficiently and effectively with the court. He has responded to the court. Some of his answers seem to fall more in line with his declaration yesterday that he's a sovereign citizen, but he has always participated in the court proceedings and never appeared to be in such a manner that he was not able to understand or assist in the proceedings. So I just wanted to make that record as well. And I think that's it for my comments, Your Honor. Thank you for the opportunity.
Thank you. Mr. Brooks,
Yes. Oh,
anything you
geez.
wanna
Oh, my.
add to the record at this
Don't
point
stop.
regarding the request?
Yes, I do. I'm trying to grasp the relevancy of that whole issue. Especially the part that was just said about me participating in everything, seeming to know everything that's going on in the proceedings up until this point. Kind of misleading a little bit, I think, by the state, because I recall it being an issue when the whole misunderstanding happened in court back in last month. I think it was the 26th, if I'm correct. It was a whole issue about me being quote unquote asleep in court. So I think that's kind of misleading to say, to raise all the competency things. I've been intelligent and all these things, and then raise the same things. That's kind of like a clash. I don't understand that. I don't understand the relevancy of it. I don't understand the
It's a clash.
relevancy of the NGI plea being referenced to when that plea was essentially withdrawn. I don't see the relevancy of prior cases with this.
Dude, they're
case in
trying to
front of
show
me
that
now.
you're
I
not
just- I don't see
incompetent
the
or
relevancy.
insane. Bro, you're so wrapped up
I
in
think
this.
you're more than capable of making the right determination based by what you have in front of you now.
He's so stupid he doesn't realize they agree with him.
Before this
Bruh.
court gives a final decision, I want to go through a little bit of the procedural history of this case, not long, and then some of the case law, because it is important as this court
It's important to
decides
protect
this
the
very
record
important issue.
on
So,
appeal.
as everyone, I think, is aware, the Waukesha Parade occurred on November 21 of 2022. I believe it was 2 days later, on November 23, that charges were filed.
Year was 21. you're
Did I
right.
say 2022? Thank you. We're in 2022. Thank you. 2021 is the incident. This case is 21 CF 1848. There's been a significant amount of litigation in this case already. There was a contested preliminary hearing. Then the first appearance occurred before Branch 2 on March 11th of 2022, about 202 days ago. It was on that date that this court set aside the month of October to hold the trial. The first trial order was issued. Many of the dates were discussed, but the trial order wasn't issued until April 11th of 2022. That is when it was formalized. Going back to the March 11th date, though, a decision was used on that date to utilize a jury questionnaire, meaning a case-specific jury questionnaire. There were related deadlines that were discussed. On March 29th, we held a hearing to discuss the questions and finalize the questionnaire. At that point, the court was alerted to the defense potentially raising a motion to adjourn. I set a motion date. The court heard and denied a motion to adjourn the trial. From my perspective, that motion was primarily related to potential concerns of the defense regarding the ability to be prepared. We discussed additional deadlines. From my perspective, this is a case where the state has worked diligently to quickly turn over all discovery material. From my understanding, again, not having reviewed all of it, that's not my function at this point, though it was very voluminous. It included paper discovery, electronic discovery, but the court set appropriate deadlines for the exchange of witness lists. Of course, Mr. Brooks initially entered a special plea on June 20th of 2022, where the plea of not guilty by reason of mental disease or defect was entered. That resulted in a certain series of events occurring. Just prior to that, I also, I think I already referenced this, finalized the first trial order April 11th. Ultimately, I amended that on July 12th of 2022 to encompass some of the issues related to the NGI. Then this court held 2 days worth of hearings on August 25 and 26 to address a variety of motions. I know you may not understand the relevance, sir, but it is important just to note that on August 26th, there was an outburst by Mr. Brooks. It resulted in the court taking an early recess, and he was temporarily removed from the courtroom. When he came back, we took a break, I should say, and then there was the outburst that resulted in the removal, but he came back. He was there, I think, for about 2 hours before he requested to leave the proceeding. But I believe the record would fully demonstrate that when I questioned him regarding his desire to leave, he demonstrated an understanding of what he was doing. He answered my questions at that time. He understood, from my perspective, that he was leaving the proceedings. Then the court moved on to September 9th. That was the jury status. On that particular date, the court essentially adjourned the proceedings. Mr. Brooks complained of a tooth abscess. I was able to fit it in with my schedule, and so the jury status was adjourned until September 19th. The jury status was held. We covered a number of issues at that time. The state raised the need or the desire to have the court rule on some additional issues. We set some deadlines for that. At no time prior to the jury status was this court ever advised of Mr. Brooks' desire to represent himself. And then it was on the 21st of September that the motion was filed. Of course, the court set the hearing initially for yesterday. Court started the hearing, essentially stopped the hearing, provided Mr. Brooks with a number of documents. Those documents are noted in the record, but he was provided with documents 42, 82, 230, 232, 233, 234, 235, 236, 237. There was a circuit court record selected, also provided to him. That's of note because that selected circuit court record also lists all of the charges. The documents that I provided to Mr. Brooks, which I believe the record also bears out, he had previously included the second amended criminal complaint and the information. The documentation also included CR 226. In preparation for the hearing yesterday and today, the court also did not only go through the procedural, look through the court record. I certainly read a number of cases, including in Wisconsin, State versus Klessig. I've already referenced the Rhodes decision. I reviewed that. I reviewed the federal decision of Amani versus Pollard. I reviewed Pickens versus State, Indiana versus Edwards. I reviewed State versus Amani, which was the predecessor to the federal decision in Amani versus Pollard. There's other cases as well, but those are essentially the critical cases for the court's determination. I also reviewed all of the Ngi evaluations as well. And my purpose in doing that, a couple of different reasons. Number one, those evaluations were done by licensed professionals, all of which I believe have a PhD after their name. And as part of those evaluations, which were done in July and August of 2022, each examiner did a mental status exam. And in each of the reports, it's noted, frankly, no concerns over Mr. Brooks's mental status. One of the criteria this court needs to look at is whether there is a mental illness that would essentially impair Mr. Brooks's ability to understand what's going on. That is because the federal cases talk about where there is a narrow class of cases in which a defendant may not be competent to represent himself at trial. In that situation, typically would be a severe mental illness to the point where they are not competent to stand trial or to conduct trial, themselves. In this particular case, I have absolutely no indication that Mr. Brooks suffers from a mental illness or mental impairment. I know his mother wrote a letter I did review it as informational only. She does not use the word, I don't believe she uses the word competent or competency, but she references her concern regarding her son being unstable and her opinion that he is making the wrong decision.
She's
I'll get
ruling
to the
right now.
Case law on that momentarily, but this is where the Ngi evaluations are of importance to the court. As I indicated, there are 4 evaluations that are on file. 3 of the 4 doctors all diagnosed Mr. Brooks with a personality disorder. I'm going to quote at length from one of the reports because I think it's important as I make a determination today that Mr. Brooks is competent to represent himself and waive his right to an attorney.
Quick
I think
objection.
it also, Mr. Brooks, you're not, don't interrupt me. It also helps explain some of the interruptions.
That's a rest
and-
judgment, Your Honor.
Not right now. You can ask when I'm done. It also, I believe,
I
helps.
object.
Mr. Brooks, let me get through this. It's really important that I make a record and honor your request
I understand that.
to
I don't understand
represent
why.
yourself.
I don't understand why.
Mr. Brooks,
um,
I'm going to explain the
something-
relevance. So
I
just
don't-
stop
I don't
talking and listen to
understand-
me.
I don't understand why something pertaining to a plea that is not standing anymore has relevancy to the decision that's being made right now, months
Stop
after.
talking and listen because you're going to get the answer. okay?
Okay.
Because you're a
I hope
moron.
so.
You got to listen.
Your Honor,
Yes.
I really don't want to interrupt, but while we are still Mr. Brooks's lawyers of record, I would, and I don't know what Your Honor is about to say and read, but I think you said you were about to quote extensively from the reports. It's my understanding that those are confidential unless there's a phase 2 of the trial. And so I don't know if it could be done by allusion, but when I heard you say you were going to quote from them, it did sort of set off warning bells.
I
in
understand.
terms of that.
I understand. And I'm mindful of that. The reports are not made
Mindful.
public until a phase 2 proceeding. That does not limit this court from relying upon the information in them in evaluating his request to represent himself in this case.
Is there a case law to back that up?
My decision
Oh
in
my God,
this
bro.
case
Bruh,
to frankly honor the request of Mr. Brooks and grant the motion today is based upon the entire record and proceedings and file in this case, including matters that are otherwise sealed to the public, but available to the parties and the court. The bottom line is this, and I can, without quoting verbatim, say this. I cannot make a finding based upon the record before me that Mr. Brooks suffers from a major mental illness that would interfere with his ability to represent himself. He may possess some challenges given what I understand about personality disorders, but those have nothing to do with his competence to represent himself. I indicated earlier that all of the doctors did a mental status evaluation. That's important because none of them noted any concerns regarding his ability to understand, regarding his having an unawareness of his surroundings, and things of that nature. They do note in a number of the evaluations regarding his level of cooperation and at times the lack thereof, his refusal to respond to questions sometimes, what I would generally refer to perhaps as some difficulty in interpersonal type communication. However, all of the examiners were able to say something to the effect that it was their opinion that Mr. Brooks reasonably understood with reasonable accuracy why the evaluators were there, the limitations of the confidentiality associated with that even during times during those evaluations, if he was being difficult, that he was nonetheless able to communicate with them. He was articulate. His remarks were coherent, fluid, at times, though they were avoidant of questions asked. I would say this, my observations of Mr. Brooks and perception over the course of the proceedings throughout this case is strikingly similar to some of the commentary and observations by the evaluators, including even the angry outbursts that we've seen in court, the avoidance in his responses to questions asked.
I object to that because at the end of the day.
I understand, Mr.
I
Brooks,
object.
stop. You
Bruh,
can object.
let her
Your objection
talk.
is noted. I'm going on. This is one of the
object.
expectations that I have. Is you can
Bruh.
object, it will be noted, but you
Bruh.
can't keep interrupting. I need to have an accurate record.
Okay.
So
you're
your
reading from
objection,
something-
sir, your
You're
objection
reading
is
from something
noted.
that I haven't been
This
privileged to
is a
read
prime
myself.
example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD,
He
Your
can
Honor.
be, in my opinion, deliberately disruptive, but nonetheless, he maintains being competent at the most basic level in order to present a defense on his behalf.
Object to that.
Now, I talked earlier about some of the case law, or at least referenced it, and I want to start with that, or I should say, start my decision, my ultimate decision at this point with the case law. The Sixth Amendment guarantees a mentally competent defendant
Yes,
the
she
right
did.
to represent himself in a criminal trial, no matter how foolish that choice may seem. This is a quote from Beretta versus California, found at 422 U.S. 806. The quote is from Imani versus Pollard, and the court in that case went on to say the following: the constitutional right, quote, exists to affirm the dignity and autonomy of the accused and to allow the presentation of what may, at least occasionally, be the accused's best possible defense. That's Imani versus Pollard quoting the McCaskill case. A judge may not deny a competent defendant's timely invocation of his right. Under Ferretta, a defendant's reason for choosing to represent himself is immaterial. Defending pro se will almost always be foolish, but the defendant has the right to make that choice for better or for worse.
Pro per.
In Wisconsin, just like in Ferretta, the court recognizes his right to represent himself. What this court needs to determine is whether Mr. Brooks is making a decision competently, freely, voluntarily, what we refer to in the case law as a knowing and voluntary waiver. That is why the court went through the advisement of the charges, the penalties that Mr. Brooks faces, why it gave Mr. Brooks form CR 226, and went through that with all of the advisements here today. That's also why the court went through the advantages of having an attorney and the disadvantages and challenges of being one's own attorney and representing oneself. I believe that the record demonstrates this court has warned Mr. Brooks about what he is getting into. the challenges, or at least some of the challenges that he may face, including on topics such as jury selection, trial objections, rules of procedure, etc. In the words of Imani versus Pollard, what this court needs to do is make sure the defendant makes the choice with eyes wide open. And that's quoting Iowa versus Tovar. I have made Mr. Brooks aware of the dangers and disadvantages of self-representation by going through not only this form, but by reviewing with him once again the charges, the penalties, the exposure that he faces. Ultimately, in the end, a competent defendant has a constitutional right to represent himself, even if the judge or anyone else thinks there may be no good reason for him to do so. I'm not saying you don't have a reason, sir. I'm frankly speaking to your mom at this point. He may not understand. Frankly, her understanding is not material. You have the constitutional right to make this choice. What's important for this court, and why I also went through some of the other biographical information, is you have a high school education. You've completed the 11th grade. You have an HSED. You are clearly literate. You've been able to communicate with the court efficiently and effectively. At times, you press the court when there is something you don't understand or believe is not going your way. But to me, that's a sign that you understand and are advocating on your behalf. Frankly, statements like "I'm informed" or "I am aware" are the functional equivalent of you saying "I understand." I cannot say that this is one of those
Everyone
narrow
said, "I
class of
understand."
Mr. Brooks.
I
Stop.
object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't
that's the
interrupt. I
procedure
interjected.
that we will
Object.
follow. At trial, what's going to happen if you continue to do that is you will be admonished in front of the jury
That's fine.
if you continue that.
That's fine.
Like I said, this is not one
Whole
of
lot
the
of
narrow
bruh
class of
moments.
cases in which a defendant may not be competent to represent himself because there's no evidence before the court to suggest he has a severe mental illness, which is why, of course, I looked at the Ngi Evaluations, because that is competent, recent information
That has
before
no
this
relevancy.
court regarding his mental status
It has no
and his
relevancy.
understanding of what is going on.
That has no relevancy to
This
why
court
we're here
has been
today.
able to render the following. It is this court's opinion in finding today that Mr. Brooks understands with reasonable accuracy and is aware of the difficulties and disadvantages of self-representation, the seriousness of the charges against him, as well as the general range of penalties, and that he is making a deliberate choice today to waive his right to an attorney and proceed without counsel. This court further finds that Mr. Brooks is competent to proceed, whether he refers to that pro per, pro se, or simply self-represented. He reads, he writes, he understands the English language. He's been able to communicate with the court. He has no physical or psychological disability that impacts his ability to communicate with the court or to communicate a defense to the jury on his behalf. I've not been able to find on the record, and he has not advised the court of any disability, physical or psychological or otherwise, that would affect his ability to communicate with the court or to a jury. In the words of Pickens, Mr. Brooks has the minimal competence necessary to conduct his own defense. I'll further find that he understands the proceedings, the nature and seriousness of the charge, the maximum penalties that can be imposed if convicted of these offenses. He understands that a lawyer may be of assistance, understands that a lawyer may be
Informed,
appointed if the
I never
defendant
said I
is indigent,
understand.
and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without
Bruh,
counsel,
come on.
and therefore the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes. And from this point forward, Mr. Brooks will proceed as his own attorney.
It's official. Thank you, Watermelon.
Does the
We'll get to that
public
in a minute.
defender's office require any type of written order discharging?
No,
All right, the minutes on CCAP will be sufficient.
yeah, that's fine.
All right, if there is the need, just simply file an order under the local rule, and I'll certainly review it and sign if appropriate.
Yeah, thank you.
Anything else you need from me today before I continue with this hearing?
From us,
No, from Attorney Perry and Attorney Keith.
from us, no.
All right, you may, you are
Fed, I
discharged
can't
and
read that one, but I
certainly
saw
are
it.
excused from the remainder of this hearing.
Your Honor, can I just clarify, as to the discovery, Attorney Perry, you indicated all paper discovery have been turned over, but not the electronic discovery, correct?
Not turned over, but it will be, we'll make arrangements with the jail.
You're gonna turn over the electronic discovery? Yeah. Okay, very
Okay,
good. Thank
okay.
you.
Yasu, you have a nice
All right, I
weekend.
know we have a number of outstanding issues. That documentation was provided to Mr. Brooks at the close of the hearing yesterday. Mr. Brooks, are you in a position to respond to that so that the court can address those outstanding issues today?
What are the outstanding issues?
Those are the documents that I gave you yesterday.
The ones that I already had?
I don't know whether you had them or not, but I specifically gave you all of the pleadings that had been filed from the motion to withdraw forward. That was provided to you yesterday.
So what are the issues?
Are you
Oh,
prepared to
Jesus
address them
Christ, bro.
today, sir?
What
You
are-
have two options, sir. We either address them right now, or I have to come back yet before the trial or decide all of them on the morning of trial, and I'd rather not do that.
That might be the way to go, because I don't know what issues you're referring to.
Oh, good Lord.
So you didn't read any of the paperwork that I gave you?
I think, Your Honor, that you should understand my position in the jail, that I'm not awarded adequate time out of my cell to get a lot of things done.
That is
There are
actually
a
a
lot
fair
of
argument.
Things that I have to go through with
Mr. Brooks,
just receiving the
Mr.
paper
Brooks,
discovery.
this is
I
really
haven't been through
simple.
all that.
I gave you, we're just gonna go through them one by one. You represent yourself, and you're gonna have to answer these, or at least provide input if that is your choice.
And these documents were personally served on Mr. Brooks in the jail, Your Honor.
Your Honor. Yeah, don't you know? He said hello in Wisconsin. Good old Sue.
All right, let's start with document number 233. I'm happy to, if you don't have, do you have documents in front of you, sir? What did you bring out from jail with you today?
I'm just going, I'm going as you go. 233.
We'll print it out for you. I don't have a problem. Madam Clerk, as we go along. This is the request from the district attorney's office requesting 2 of the public seats in the gallery for victim witness. Do you have any objection to that request?
Can I see the actual request?
You finding it, Teresa? 233. You're gonna need to print the rest of them as well, but I think the printer can be a bit loud, so we'll print them off and then I'll ask questions. Two, three, four, 235, 236, 237.
Guys, you guys have asked a bunch of really good questions. And if you send in a super chat, I'm going to answer them in a little bit. But let's scroll through some of these real quick while we're here. I guess we'll start off with the first one. People have asked them multiple times. Wisconsin is not a death penalty state. This is not a death penalty case. Wisconsin has not had the death penalty since like 1850 something. So Graham, you asked a long time ago, how is pro per different from pro se? Just the words in Latin, but ultimately it is the exact same thing. Courts treat it the exact same way. Prior persona
I think he was strong, right?
is how propria persona is how sovereign citizens like to style it. Joe Moms brought up something really interesting, and I think this is important. He does not understand things because under sovereign citizen terminology, that means he's standing under, meaning he is below the authority of the court and what he may perceive as an illegitimate government. And that's true. That's why they don't understand things, he said, as it was mentioned to me or as it was explained. That's why he crossed out the words understand, because he's not standing under anyone. He is a free sovereign individual. And that's a big deal for them. They believe those words matter. Brandon Lesko saying, imagine how insulting it must be as a lawyer to have this whack job claiming you're incompetent. It's part of the territory. They have this happen all the time. I've had it happen all the time too.
Yes.
It's not the first time. It won't be the last. So it's not that big a deal. And Katie is asking, why does this attorney, and that's his attorney, seem to be careful in what he's saying? Because it's making sure everything is explicitly stated on the record. And also it's clear Darrell Brooks is, if you say the wrong thing, he gets all upset and starts acting like an asshole. So you're going to be very careful and choose your words in a way that keeps it from getting upset. Parallax, you asked, if you're the public defender, are you actively wanting to represent this guy if he's trying to get you removed?
Let me know when you've read it, okay?
Yes, 100% you are. Your
I'm just
job
gonna
is to
start with
represent him.
233, okay?
Yes, ma'am.
Your job is to do the work. So until you're removed, you're fighting. And those two were prepared to go to trial on Monday until they're told they're not having to. And they will do their damnedest to represent him. So yeah, but you're a professional. That's how you roll. Do they have soft citizen courses in jail? No, but they talk to each other. A lot of jailhouse lawyering going on.
Already trying.
Oh, come back to
Right,
these.
so the first paragraph, the state requests 2 seats that be reserved in the public seating for victim witness advocates to be present in the courtroom. Do you have any objection to that?
Not really. I just would want to know, would that involve a lot of coming and going? Because I know you stressed that you wouldn't want a lot of movement, getting up, leaving, coming back, getting up, leaving, coming back, sort of thing. But would that involve any of that?
My trial order remains as is, and they would need to abide by that.
Okay. No objection to that then. I was just unsure because it says to assist victims with whatever needs they may have. So I didn't know if that may involve somebody might need tissue, need a drink of water or something like that. Would that interrupt the proceedings? That's all.
The request is granted. Then as it relates to the request for Spanish interpreter, Mr. Brooks, you should be aware that during the meeting I held with the attorneys yesterday in my jury room, which you were not present at, I advised the state that there's a state form regarding the use of interpreters that I needed the state to fill that form out as to each request being made, because that form will assist the court in appropriately scheduling the interpreters, or could be one, could be more than one, because part of that form is to tell me what day and what time the interpreter is needed. And so it's my understanding the state's going to work on that. I have an obligation under the law to provide interpreter services for the parties, if need be, for victims, for witnesses. And so I am working on that. Any questions about that?
Yes, it says right here that those victims will potentially testify. Would the testimony then be in Spanish?
We would have an interpreter and the testimony would be interpreted. And so both of the answers in Spanish and the interpreter would be placed on the record. That's the purpose of an interpreter.
So there would be a counterpart to that in English so that I would know exactly what's being said,
That's what the interpreter would do.
right? But how would I?
I can't answer that, sir. The interpreter will assist the court, the jury, and the parties to understand the answers that are provided.
Yeah, that's all I'm asking. I just want everything to be exact, because I know sometimes in Spanish, some words are kind of pronounced different. They mean certain things in English. So I just want to make sure that everything that's said in Spanish will be interpreted correctly in English.
That is why we have an interpreter.
There are victims who are
All right.
likely and witnesses who are Spanish speaking.
Anything else the state needs to put on the record on that?
No, Your Honor.
Will I be notified of that too? When
Because you are representing yourself, sir, you will get copies of all filings that are made.
Yes,
to
he
the
did.
court or with the court. Attorney Opper, you, in your last paragraph, reference the exhibits.
Apper.
I thought I did a test yesterday so I could answer this question, and
300
I'm
viewers,
not
guys.
sure
Thank you
why.
very
It could
much.
be depends on what screen, at least, I don't know. I'll do another test. My understanding is I will be able to share screen, okay?
Okay.
Whether it's your paralegal, right, would need to be in my Zoom. And then I could allow an exhibit to be published that way. And so it would impact the Zoom because it becomes the big screen and there's just a little box with the rest of court. But that's the only way I'm able to have people from a remote location see
This is all
what's
new
being
today.
presented in the courtroom. Does that make sense?
Yes, I appreciate that. And with your permission, Your Honor, I can work with the IT personnel on that and make sure we can accommodate that.
Any questions, Mr. Brooks?
just 1 second, Your Honor, if I may. Just a quick second.
Okay. So, guys, yeah, the whole issue about the interpreter, there are likely some witnesses and or victims who are Spanish speaking. So that's why the court provides
I want
interpreters.
to put the court on notice that I would have essentially people that would come to the trial, and I don't know how you would feel about victims potentially being in the same area with.
My trial order addresses there's a row reserved for your family.
Is it just one row? Because I'm not sure. I
Yes.
don't know the exact number of people that will come. I know I have some people that express wanting to come from out of town, which would be.
Sir,
Ain't nobody
my
coming,
trial
bro.
order was given to you yesterday. It explains, it's the administrative order. It explains what seats will be reserved and for whom, so that I can accommodate the public, the press, the victims, and your
I'll
family.
answer this.
What I'm asking is there a number? Is it a limit?
It's a row. I've reserved a row.
Pretty much.
So the first row behind you will, I can't tell you the max on that.
That's what I'm.
Lieutenant, can you tell me, is it 8, 10? Probably 8. So 8 individuals, and I will be live streaming to accommodate, right, the interest in this case, so any other individuals would be able to watch that way.
If they were here, they would,
I can only have so many people in this courtroom, sir,
So
so
then
we'll have to kind of
essentially-
wait and see. What I told the state and what I tell you is depending on the interest, I may have to adjust what's in my order, but the order clearly states that if there are open seats available after 15 minutes of the start of the morning and of the afternoon, then other people can fill those in wherever they may be. All right. Then let's go to 235. 234 is not, it's a moot point at this point. So 235 is the request to prohibit video recording or photographing of participants. You see that document, sir?
yeah,
God, this is painfully slow. But going back to the interpreter, the court has to provide the interpreter. That way it's a fair and impartial interpreter. If Brooks were to provide his own or the prosecutor would provide their own, there would be questions about their bias and partiality. So the court provides the interpreter. That way there's no question about the interpreter. They're impartial and they translate literally everything that's said to them, and then also from the court, but also said to them by the witness. So just wanted to cover that part.
so one of my questions would be, I have expressed when I did have my attorneys that I would essentially be having my own witness list. And I don't know if that will conflict with the state's list. I don't know if some of the people
Doesn't matter if they conflict.
that I would want to subpoena would be on their list already. I know some of them won't. With that same, I guess, rule or order or whatever apply to those witnesses, witnesses as well.
I don't have a request for that at the moment, so the answer would be no.
And can you clarify that for me?
I don't have a request before the court at this point to limit showing faces of anyone other than what's in this request. I can't answer what I don't have in front of me. So if you need to make that request, you'll need to do that, but that's not what I'm considering here today. I'm only considering the request that's in this.
I'll be making that request.
You have to, what I'm gonna require you to do, sir, is when you are making requests like that, you can go back to your cell and file an inmate communication form, make those requests in writing, and then tell the COs it needs to get to me, and then it'll get to me, and then it'll get uploaded, and then the state gets a copy of it.
Yeah, I'll definitely be doing that. I just
And
wanted
then
to.
if you have, while we're talking, if there are witnesses that you intend to call, you need to let us know right away. I don't serve subpoenas, right? There are subpoena forms I can have you fill out. It's my understanding the state may assist you if they don't have to, but they may be willing to if those witnesses are also on their list. Is that right, Attorney Hopper?
Yes, if they are on our list and they've been given notice by us for the trial, we're certainly willing to extend our subpoena to Mr. Brooks.
That is very nice of
You
them.
understand that?
That is very, very nice of them to do that.
I follow.
So if there are other people, then you need to I can't give you legal advice, sir, but I had a trial order that governed the naming of witnesses, right? And there are requirements to require witnesses to come to court and testify on your behalf. You're gonna need to figure that out.
Shouldn't be too hard. I just wanted to make sure that our witness list wouldn't conflict.
I only have the witness list from that your
Shouldn't be
previous
too
attorney's
hard.
file.
Jesus, bro.
That's all I have.
I don't have that, Your Honor.
We'll make sure you get a copy of it. All right. So so Attorney Opper, I do want a little bit of argument from you on this in terms of, I know the SCR that you have cited. I had hoped I would get not a broad request. I think victims are different than just citizen witnesses. It's a discretionary determination by the court. I need to find cause. I understand this is a case of, it has received a lot of attention. It of course is going to be live streamed and covered by the media.
Oh, yeah, it is.
But I need to make a request that it's for cause. So I need to know who those people are. I mean, I'm not going to entertain a blanket rule. I can tell you that much.
I'm sorry?
I'm not going to entertain a blanket rule.
Sure, okay, I understand. And yes, we certainly are proposing that victims are in a much different position than civilian witnesses. And that's because of the Constitution and the statutory right to privacy that is conferred upon them. And in fact, the Supreme Court rule that I relied on says there's a presumption of validity when it specifically involves victims of crimes. So that's what puts them in a whole different category, Your Honor, in our opinion. I don't know how, to my mind, Your Honor, to protect their right to privacy, we would not be doing so by showing their names and faces and voices over the internet or to the media for a crime victim. We attempted to be reasonable in our request. We understand this is not every witness the state will call to the stand. In fact, as I've indicated, police officers, expert witnesses, things like that, we're not making the request. We understand there's an interest in this case for the public, and we appreciate that. And we appreciate that Mr. Brooks has the right to a public trial, and we appreciate the public's right to know. As it relates specifically to citizen witnesses, Your Honor, and I could certainly provide a list of names to the court. I apologize for my failure to do that. This gets a little bit fact intensive because we would argue that really anybody that was at that parade that day was impacted. So you can have a witness to maybe a traffic accident or a shoplifting incident, and they're not personally impacted. In our experience, Your Honor, in speaking with these people, many of them, even those who were not injured, who did not have family members or close friends put in harm's way, saw something that impacted them, and it will be difficult for them to come to court and testify and relive that experience, quite frankly. Many of them requested of us, as we spoke to them, an appreciation if the court would consider, again, given the unique nature of this case, the very disturbing images that are involved for them as they relive this, and the disturbing images that may be projected during their testimony in form of video or photographs, that there is good cause, Your Honor, to accept our request not to show their faces. We made a distinction, again, trying to be reasonable and understanding the court has to balance a lot of interests here, that for a civilian witness, their voice could be recorded. And I've seen it on other occasions, Your Honor.
I wish.
Where the cameraman is simply directed to show the person from the shoulders down or show only their hands or whatever it is. They're very creative and very, very good at that. In my opinion, I've seen that in the past. Their voices can be captured. As to victims, we don't think so. We don't think there's significant protection of their right to privacy by even capturing their voice. So I can certainly provide a specific list to the court, but I can tell you that many of the people that we've been talking to as we prepare for this trial, citizens, ordinary citizens who, again, just had the bad luck of being in the wrong place at the wrong time to witness this, not through any choice of their own, but by subpoena of the state, are going to be asked to come here and relive this horrific event. So that's what we base the request on, Your Honor, to respect their privacy, not as a victim, but as a witness.
Is there any case law on this issue, at least the SCR 61.11
I
that
could
you're aware of?
find no case law, Your Honor.
I don't like this idea of not showing their faces. It
This
should be
is the
seen.
only authority I could find.
Mr. Brooks, do you have any position on the request?
I do. I think that if those particular witnesses have expressed the emotional strain that they would go through by having to come to court and relive seeing videos or just hearing certain testimony and things like that, it would probably make sense to just remove them from the list altogether. That will cut down
My
on
man.
the amount of time spent during the trial. 'Cause I'm quite sure there are going to be some long days and some
God,
not so
that's
long
good.
days. But I think why not just remove those people altogether
Ah.
to end the time and save those people from having to go through that if they've already expressed not wanting to do it in the first place.
Absolute madman.
And as far as I do understand what the state's position on certain people not wanting to be shown their face, not to be filmed. That's understandable, and a lot of what they're saying I agree with. But what I don't agree with is the time that we live in right now, with pretty much everything is at our fingertips, whether by Google, whether by social media or different types of things like that. It wouldn't be that difficult for just the name to be solved, and then somebody somewhere might want to just Google that name and find out information about that
Thug love,
particular
dude.
witness. So I don't think either way is really protecting them from anything. I think if they choose to be a witness in this case, they're pretty much, the public is going to know who they are. So I would think it would be more logical to just remove them off the list altogether.
Fucking stone cold. That is beautiful. I mean, man. Speaking of my mind
The issue
here.
of removing people from a witness list is not before the court, Mr. Brooks. The issue is limited to whether I will allow the images of the witnesses to be broadcast on the live stream or by the media. Of course, any witness who testifies in this case will have to do so from the witness stand, which is to my right. This is a public trial. Anyone could come in and see the witnesses, listen to their testimony. All witnesses identify themselves. I think you make a interesting argument about the social media and access to information about people in general.
Very credible. It's a very good
pretty
argument.
astute, Mr. Brooks, because what I don't have on the record before me is really the ability to make a for-cause determination,
Oh,
with perhaps one exception. And that would be for juveniles who are minors. I think juveniles and people under the age of 18 have some added protections. Of course, all victims have the right to privacy under the statute and under the Wisconsin Constitution, but I need to balance all of that with the right to a fair trial, the right of the public to be present, the right of the media, right, the right of the press to cover this trial. I think I balance that with the fact that Mr. Brooks's images and the images of the parties have been on media on sometimes a daily basis. There's been no limitation on what images of him have been put out. This court has been live streaming the proceedings from the beginning. There's a practical consideration that the courts, meaning me, I am utilizing Zoom and the live stream capability. While the media is also present, they are independently filming these proceedings. So I think I need to I need to distinguish between that. The live stream, once it's down, it's down. I'm fully aware that it's down from the court. I should say that my order allows people to capture that. And so for all practical purposes, it's probably really no different than what the media is capturing. I said this before, and I think it's a very important consideration. I am live streaming in part to assist victims so that they can view the proceedings, to assist the public and the press, because as everyone I think is well aware, this is not a very large courtroom in terms of the gallery seating. I had 8 benches in this courtroom. Given the magnitude of the case, and in particular, when I say magnitude, the number of people impacted, the victim key in this case has pages of individuals identified going to triple letters. I can't fit everyone in this courtroom. And so I need to utilize the technology that I have available, which is the Zoom technology, which picks up the 4 cameras in this courtroom. And that then in turn gives me the ability to live stream, which I think is important for all of the reasons that I've just indicated. So the practical consideration is I also need to be attentive to this trial, to what witnesses are saying, to objections that parties are making. I have to take my own notes, right? There can be motions that are raised where I need to refer back to those things. And so from a practical standpoint, it's challenging for this court to say, I'm going to limit what's being captured by the live stream. I mean, right now, if you were to look on the boxes that you have, I mean, there's a far back view, but that's normally the view that is on the witness stand. And so you see me, you see Mr. Brooks, you see the attorneys. I mean, the witness would really be similar in size to what you see me. And so I just raised that because it presents a challenge to knowing, you know, who that applies to if I were to grant it and who it does not. I realize you can put me on advance notice and all of that, but that's only part of the equation, right? I've talked about the right to a public trial. I do not want to be insensitive to the impact of testifying and what it can have on anyone. I've certainly seen that played out in my courtroom a variety of times. And I don't want to be insensitive to the emotional toll on the people involved in this case. Like I said, I need to balance everything that I've already referenced. What I will do is as follows. If there is a juvenile witness, I'm going to require the state to give me ample notice so that I can adjust. I can't turn off a camera in this courtroom. I can't. So I have to adjust the camera and either put it very far back or put it in such a way that perhaps is from the shoulders down. I'm not going to limit audio in any situation. That's important so that people observing this, not the least of which are victims who might be observing from a remote location, even in this building, be able to see and hear the testimony. But I am willing with a juvenile, witness to limit and require, I guess, the court and the media to only capture from the shoulder down. So that would prohibit the media from capturing a juvenile witness's face. Of course, we'll be able to hear them. All witnesses, like I've already said, they state their name on the record. Many of the names of the individuals, despite the court proceedings, are very well known to the public. I have seen every victim of the homicide charges names in the media repeatedly. So there's obviously no reason to somehow limit coverage of that. That's not exactly what we're talking about, but there's other victims whose stories have been in the paper, whose names that are out there. And like I said, I think if I'm doing my job correctly, I have to do a balancing. How much information is out there? I really don't know. I'm being asked to issue a blanket rule for all victims and all witnesses, and that's just not something this court is willing to do. So like I said, with the exception for a juvenile witness or victim, I think it's appropriate. I understand what the SCR says, but in terms of all other individuals, I'm going to deny the request and find that on balance, the right to a public trial, even the broadcasting of that information is an important part of what goes on. It lends to the transparency of what we're doing in this courtroom. And I think in turn leads to public confidence in what we're doing in this courtroom.
Wow, he pulled one off. Good
So is that
job. Good job,
ruling
Darrell.
you're not distinguishing between victims and witnesses?
I am not. I understand what the SCR says. I understand what the Constitution about the right to privacy, but this is a public trial.
But we've
And
done nothing to protect their privacy for victims, Your Honor. Literally nothing.
I understand
You're
that's
on
my
here.
ruling.
It doesn't matter. You're
So
justifying,
I
bro.
think it's important that this case be public, and it be public in all respects, other than the only limitation will be as to a juvenile witness, given their young age. I understand what you're saying, but that's my ruling and I need to move on.
BTFO'd.
The next
Kadoosh.
request, I believe, is document 236. And this is the brief that was submitted by the state in support of victims attending the trial, which would be an exception to the exclusion of witnesses. That's a little bit more lengthy document, so take a moment to review that.
Okay, so yeah, that was really nice. The MILF Milker. Yes, I can recap what happened. Darrell Brooks raised a motion about the
And
identities.
I know you were handed some things, Mr. Brooks, so we're looking at document 236.
Yeah,
It-
I had that.
the
right here.
identities of all witnesses and victims not to be shielded from the court and not to be shielded from the press when they come to testify. So sometimes they'll make the hand, they'll film the hands or something else when these people are testifying if they don't want to be disclosed. And he brought
I
up,
just want to further add one thing to my ruling on this. And I understand, Attorney Opper, what you're saying, but I think also part and parcel was that the vast majority, as I understand the witnesses, right, they all attended a public event as well. So these were people who went out in public. I realize they didn't go there to be injured or hurt, but it was a public event. And I think that lends to my decision to deny the request here.
this
today.
woman is so based.
So, Mr. Brooks, let me know when you have finished reviewing that so I can address this last
So-
request, or the request in this filing.
Yes, Your Honor.
So all the witnesses and victims are going to have to testify unless they're a juvenile with their faces and identities known. Darrell pointed out this is a public trial. This is not like Social media, you can figure out who these people are in 2 seconds anyway. There's going to be no real benefit to it. He has the right to have a public trial where everybody gets to see everything on the record. And the judge 100% agrees. So that was very impressive that he made that argument. I mean, I've made that argument myself before, but I've also never had a trial that's gone on TV like this. So, but no, good job by him. Now, getting back to catching up to what you guys were talking about and getting through some of these super chats and old stuff. Brandon, let's go for $10. Thank you for the super chat, Brandon. I appreciate it so much. I know what we're doing. We're wasting tax dollars. Yes, we are. So Catnip Dave's scratching post said, is this hand-holding a way to prolong the jury part of the trial, hoping for some obscure rule to help him in some way? No. The reason why this took so long is the judge wanted to protect the record and show and lay out all the reasons why she thought he was capable and competent to represent himself. And that's what she went so slow to make sure there are no issues at trial. And if he does start trying to sabotage it, that he's already baked his cake and that he can't switch it. It's all about protecting the record. So, Brandon, let's go again for another $10 super chat. Brandon, thank you so much. I apologize. We want to get to these when we're in a lull. The audio boosting plug-in fun bucks. Not as good as boozy bucks, but hey, we'll take it. Matthew was asking, can the judge allow him to go pro se, set someone to standby counsel, and then make them take over when he gets out of hand? No. In this situation, there is no standby counsel. He's on his own. You want more sovereign citizen content? We'll probably do a little more of that as we go. Deep Surface for a $2 super chat. Thank you so much. I appreciate the support. Maybe lower your volume since the cord is so low. We got that fixed, so hopefully it's all good now. Crazy Cat Queen is saying, why the fuck isn't his lawyer telling him to shut the fuck up? Because this guy's trying to show he can represent himself. His attorney can't really get involved there. Analytical one is saying, why does the judge just make a ruling clearly he's not fit? The competency that you might think of in insanity for a normal person versus someone in the courtroom, the court standards are so much higher. Can he read and write the English language? Does he understand what he's doing? Does he want to do it? Does he understand what that's going to do? Yeah, well, then he can represent himself. David Davidson said oh, hold on here. So this is David Davidson saying, a wild bee Ivory Lamar appears. So Diablo Rojas saying, I don't get why you wouldn't use a free attorney if you're given a free attorney. That's because you're not stupid. But Darrell is. Can be. The milk judge is way too patient and nice.
All right, so
Yeah.
thank you for letting me know. And Attorney Upper, I'll hear you on this request.
Thank you, Your Honor. Your Honor, I did cite for you the statutory authority and obviously the constitutional provisions that are at stake here.
Nothing wrong with that.
There is a specific statutory exception under 906.15 sub 2 sub D that victims should not be excluded from the courtroom, and that their mere presence during the testimony of another victim or witness is not on its own enough. Obviously, you're going to give Mr. Brooks an opportunity to respond, but to date, the defense has not identified any other concern that would be caused by victims being present in the courtroom. Victims have an absolute constitutional right to be present at trial. The brief laid out our factual basis for this, Your Honor, that I really won't repeat myself, but the essence of it is that not every victim, not every person who's named as a victim will testify in this case. There are a lot of citizen witnesses, there are a lot of police officers, there are expert witnesses as well. The majority of our witnesses would not be categorized as victims. So there's very limited risk, I think, by the court allowing victims to hear testimony from another victim. The other individuals, of course, will obey the
Fuck
order.
that separation of witnesses.
As I described for the court last week, I think it was, we're at the status hearing. Many of these victims don't know what happened later down the road, literally later down the road. They can only testify as to their limited, the area immediately around them, the people immediately around them. We don't expect that a victim who testifies about the events in the 100 block of Main Street knows anything about what happened in the 400 block of Main Street. So there's really very, very little risk to these victims hearing each other's testimony. As I pointed out, none of these victims will identify Mr. Brooks as the driver of the car. We have many other people that will identify Mr. Brooks as the driver of the car, but not crime victims. We have recording, photographic proof that Mr. Brooks was the driver of the car. So identification is not an issue in this case, like in some other cases. Also, just that very fact, Your Honor, that almost all of the parade route is captured by some form of video or photographic evidence as to what happened. 5 out of the 6 deceased victims, sadly, their collision with Mr. Brooks' vehicle was recorded on video. So it's not really a matter of these witnesses describing what happened and the jury having only that to rely on, like in so many other cases where you don't have videotape evidence as to what happened. There's going to be no question in this jury's mind what happened, who was driving, and how these people were injured and killed. So again, the risk there, I think, is very minimal under that circumstance. We just, again, feel strongly, I know the court recognizes the trauma to these victims, but many of them have expressed an interest in attending this trial. We've talked about this before when we talked about the seating. Many of them feel very strongly they were willing to take off work for a month and sit here all day, every day if they could. And so the fact that they are needed to recount a limited piece of the story for their portion of the testimony should not prevent them from being present in this courtroom as the trial unfolds. We have a very well-designed plan on how to present this trial, or excuse me, this case to the jury in an efficient fashion. But we can't tell the story all at once, right? We need to do that. We need to march down that road. And that's exactly what we intend to do. And so it'd be very unfair to the victims that happen to have been standing or sitting in the 400 block of Main Street that they can't hear all the other testimony prior to that. It will be a much less efficient presentation that we can present. I think it would be extremely confusing to the jury if that happens, Your Honor. So mostly because of their constitutional right to attend trial, we believe, and the strong statutory authority. I could find no case law published on this point. And I don't mean to be disrespectful, but I really think it's just that obvious. The statute says victims are not part of this exclusion order. They are an exception.
Would you agree that if I grant this request, it would nonetheless be appropriate for the court to order a prohibition that the witnesses not discuss their testimony with any other witness?
Yes, absolutely. We've already begun that process with
His
the
Sixth
victims
Amendment
that we
right
met with,
trumps
Your Honor,
all.
telling them how important it is that they not talk amongst themselves. That order we certainly understand and would respect and would enforce.
Thank you. Mr. Brooks, do you have a position on the request?
Yes, I do. Your Honor, I think fundamentally it would be impossible for all these witnesses that want to attend to have not heard different stories from different people who were at different places in the parade. I think by now it's somewhat removed from the incident, but the media coverage alone, the reports that have been in the press, the some of the witnesses aren't even in campaign ads for elections that are coming up. I think it's pretty logical that a lot of these victims have heard a lot of, if probably not the majority of everybody's story. I do agree with the fact that you make that very clear that it is public. They certainly should have a right to be here. And you also made it clear that there is a live stream available as well. You also made it clear that everybody is not going to be able to fit in the courtroom, no matter how much they want to attend
He's
the
making
trial or
good-
not. The live stream is
Surprisingly.
available for them. I just think I wouldn't go as far as to say it will be confusing to the jury, but it would be issues, I believe. What if some of these witnesses are some of the witnesses that gave statements, and something that comes up in somebody else's phone, you might not spark something in them and say, oh, I forgot to say that. And then now that becomes a discussion, which I don't think anybody would not have had a discussion amongst themselves of what they have heard to this point and what they will hear. I'm quite sure there'll be a lot of breaks during the trial. I think it would virtually be impossible for somebody not to have a statement or to make a statement, or for somebody to overhear something that may want to be brought to the attention of the state or victim advocate or something like that, that may find its way into testimony that probably wouldn't have been there from the beginning. So I think I would agree with when they were my attorneys with they filed.
But I fired him.
So do you agree or disagree with the request from the state?
I disagree.
You object?
I object, sorry.
No, I asked you the first way, so that's okay. All right, thank you. This situation and this request is a little bit different than even the previous one, where all I was being asked to rely upon was primarily an SCR provision, and the constitutional and statutory provisions would need to be interpreted to include the request that was being made. This is very different. There's a specific statutory provision and a constitutional provision regarding the right of a victim to attend all proceedings, including trial. And there's a clear language in the statute in 906:15 that says the presence of a victim during the testimony of other witnesses may not itself be a basis for a finding that exclusion of the victim is necessary to provide a fair trial for the defendant. This request I am going to grant that the state is making, and that is because I have the ability and will order that all witnesses not discuss their testimony with any other witness. And that's a general rule that's really in place in any case. And it will bind these witnesses until they're released from their subpoena. Meaning if you have two witnesses who are from the same family, for example, and they testify one in the morning, one in the afternoon, and they're done testifying at that point, I mean, obviously then it's not as important that they follow this, and I would relieve them of that obligation. But the bottom line is this, the victims can attend, but they can't discuss their testimony with any other victims or witnesses until after they have testified. The prohibition would nonetheless apply to they can't also discuss their testimony with someone who hasn't already testified. Attorney Opper, would you be satisfied with the phrasing that they just not discuss their testimony with another witness?
Yes,
Okay, and you'll advise all of your witnesses of this requirement and this prohibition.
yes, absolutely. As I said, we've done that orally and we plan to give them something in writing to reinforce that.
All right. Thank you. I know we had some other issues, but I think I'm trying to,
I think it was just the voir dire questions, Your Honor. That's the last outstanding issue that we.
The voir dire. Say that
in
again.
my script, or that you had submitted another, I think, request.
Say that again.
We had submitted one, and then the defense attorneys had submitted some other questions, and then a request to question some people.
So, Mr. Brooks, I need you to be aware that if you want me to address a request that your attorneys have previously filed, you need to specifically tell me. And there are some outstanding requests, or at least requests that they made. One was regarding, it was filed on September 26th. It's document number 232. I'm not sure, did I give that to you or not? If it wasn't given to you, I'm going to give it to you. I'm not looking for an answer today. It's a little bit lengthier. It has to do with the jury questionnaires and whether individual voir dire should be done. What I will tell you, sir, is that I am working with the clerk of court's office so that for each day of jury selection, you are given a binder for use in court only of the jury questionnaires, so that you can know about the individuals who are appearing in the jury box for jury selection. Does that make sense?
Yes, ma'am.
So I don't expect you to be able to answer that right now, but we'll make sure you have that document. But I think what's fairly easy to address right now would be the questions that your attorney or question your attorneys ask
Yes.
this court to ask during the jury selection process. And that's also in that document. The question, is in that letter. From my perspective, I'm assuming the state, and I don't want to jump the gun here, but I'm assuming you might not object to that. It's on the political ads.
Yeah, no objection.
So take a look at that. My inclination will be to ask at least some form of a question or questions related to whether any of the jurors who are coming in for jury selection have been exposed to the political advertisements, and whether because of that, they have formed an opinion about your guilt or innocence.
What number document is that?
I don't know if you have that. That's 232. Yeah, we'll print that off for you. But
It's almost
frankly, I
5.
think it's important, and so I'm gonna ask questions related to that during the jury selection process. The other part of that letter, though, you need to review and let me know if you're asking that I question individuals that are identified in this letter. Does that make sense? It'll make more sense when you get the document, I'm sure.
Thank
The
you.
bottom line is, sirs, generally speaking, I'm not required to incorporate all the filings from your attorneys because you have now discharged them and you're representing yourself. So you need to specifically tell me if there's any filings that are outstanding that you believe should be raised. The bottom line is you're now your attorney, and I don't want to make assumptions that you want me to address issues. Does that make sense?
Yes, ma'am.
Okay. What was and then the document from the state, tell me that document number.
237.
I'm sorry, what is it?
237, I believe.
Okay. Do you have that document, sir?
Yes, Your Honor, 237, yes.
So have you been able to read that question? That their state is asking that I ask during jury selection?
Sorry, Nicole, I get pissed off when it
Yeah,
happens, so
okay.
I'll check on that.
Any objection to the court asking that question during jury selection?
No,
And you know, just to clarify, I believe that question was,
I recall.
okay.
It's actually the supplemental questionnaire, not questionnaire, but there's like 3 or 4 questions I'm going to give to the jurors as they come in and check in on Monday. So first 105. One of the questions is going to be something to the effect of, please review your questionnaire. Are there any answers? Upon review, are there any answers that you would change here today? So that, and then that information is going to be given to you before they ever come in the courtroom. And one of the questions we are going to also put on there is this question that we're just seeing.
I have a question, Your Honor, about the questionnaires. If I had certain questions that weren't in there that I think may be relevant, is that a possibility to get them in there?
Not the questionnaire, but during the jury selection process. I'm trying to avoid real specific questions in the supplement, other than if I think it might identify someone who might have a bias or a prejudice or otherwise not be someone who would be a good juror on this case. One of the questions you may recall from the jury status hearing is, I want to ask a question, and I will be putting it on the supplemental questionnaire about whether any of the potential jurors made a claim to, I'm drawing a blank on, I think it was through the Waukesha County Community Foundation
Yeah, or United Way.
or something like that. Just,
yeah.
did any of them make a claim for financial claim?
I do recall you.
Right, so that was something that's important because there's a statutory bias issue that I need to uncover, and financial interest in a case would be one of those. So I'm going to include that. I'm going to include having them look over and tell us if any of their answers have changed between when they first filled it out and today, meaning on Monday. And then the state is asking for this particular question as well. And there were some other questions. I just don't have that paperwork at my fingertips that I thought I had agreed to include from that last hearing.
It was so many questions.
Yeah, this is just going to be 4 or 5 questions
Okay.
on top of those. And then I have a whole script. I'll have to put together some information for you, sir. I generally do the jury selection process. I've done it. I ask a lot of questions of jurors. I frankly take away from the attorneys the ability to ask a lot of questions. This is a special case. I have indicated I will give the parties the opportunity to ask appropriate follow-up questions of the jurors. So those questions that you're thinking of that maybe weren't in there, you should be writing them down and be prepared to ask them. There may be certain jurors that we also have to ask questions of individually based upon either their answers in the questionnaire or things that come up during the jury selection process. For example, if a juror indicates that they have had exposure to coverage, whether live stream, whether it be newspaper reports, I may want to question those people outside the presence of the other jurors, because believe it or not, many jurors have really not read a lot. I know that from the jury questionnaires. And I don't want to put information in another juror's head that isn't there. And so sometimes we ask those types of questions outside the presence of other jurors, still within the presence of all of us in the courtroom. Does that make sense?
Yeah, it does. I just want to say too, you know, sometimes reading something and seeing something can be different things. Like it's virtually impossible to not turn on the TV these days and not see something directly related to
That's why I watch a
Impossible.
lot of Netflix, sir.
this.
So I don't have to watch a lot
I
of that.
remember
Believe
those
it or not,
days.
you're gonna run into a lot of jurors that
I
do that as
remember
well.
those days.
So, all right. I think
remember
that
those days
addresses
before I
those.
killed
know
everyone.
I need to finalize that. That's on my list of things to do, along with the script for jury selection. And I will be getting that to the parties just as quickly as I can. Is there anything else I need to address today from the state's perspective?
No, nothing, thank you, Judge.
Anything, Mr. Brooks, you think I need to address today?
No, not at this time.
All right, then that will conclude our hearing. I will get paperwork to you and actually both parties.
Poll is up.
And we will plan on convening on Monday morning at 8:30 for the start of jury selection. Thank you, everyone. We are in recess.
Wow, that was a very interesting 3 hours.
No, I guess. Okay.
You're saying, what's this guy's game? He's a lunatic. That's what his game is. Yeah, Prima, there was better resolution, but people were asking for the closed captioning, so I wanted to be able to provide that for them. So I apologize. I thought that'd be better overall. They got them in leg chains too. Oh, hell yeah, they do. Anyways, guys, wow, thank you for all the people watching. But let's get to some of these questions. We'll finish these up right now since we've got to get through them. A common lawyer asked, there are literally so many books about criminal law. Why do they always go to Black's Law Dictionary? Because they're idiots and think that's how lawyers do things. Bosif is saying the Dindu version. Alpha Fox is saying, how many times have I ever used Black's? And if I did use it, I'm sure it wasn't the 3rd edition. I've never actually used Black's Law Dictionary, so never needed to. A-Dubs is asking why have no networks picked this case up. I think you know the answer why. Amy blocked by Boozy. Wow, welcome to the club. Is she just protecting the trial and verdict from appeal? 100%. She is making it abundantly clear and laying out the record that he wanted to do this and it was on his own. Kim Berger for $9.99 with the super chat. Thank you for your support. I appreciate it. Please cover the whole trial if you're able. I will be able to cover parts of the trial, just not the whole thing. I guess I'll try to cover some of the jury selection next week because this will be hilarious, but probably not first thing Monday. I have a very important pretrial hearing that I've got Monday morning, and then I might be able to cover it in the afternoon. By the way, if you guys are new and you haven't seen me before, my name's Sean Martin, and I go by Potentially Criminal. I am a defense attorney in Cleveland, the Cleveland area. So I kind of do this on the side. I practice full time, so I won't be here first thing in the morning, but I will probably be in the afternoon. Cool Frog, thank you for becoming a member. I appreciate the support. Half Irish says, "What are the benefits of representing yourself?" Not really any. Dick Saucer for a voir dire question. He's going to ask, "Excuse me, ma'am, juror number 34. Do you love black people?" Bocephus, actually, this is a good question. Is it improper to stand to address the court, or is that only for trial, or not all courts do it? Combination of everything. Some courts you have to stand to address. Generally, you always do it at trial, but it depends on the judge. But in a hearing like this, where there's a lot of back and forth, and they're going to be talking a lot, the judges don't necessarily need you like stand up, sit down, stand up, sit down, stand up, sit down, stand up. That would be a bit ridiculous. So not every court. I mean, a lot of judges will just say, "Look, just stay seated. We'll be there." Sip It Ain't Easy said, "Why are the lawyers there with him?" Well, until the judge said you are fully discharged and excused from your duties as attorneys of record, they're still on the hook. So up until that very last moment, they're still his attorneys. They can't just leave. Magnus Kirsu says, "Does he have any experience indicating ability to take on all these duties?" No, he's an idiot. So he'll crash and burn. Mr. Squiggles said, "Pro screwed." Yes. Scuba John says she's given him so many outs. Very definitely, she gave him a lot of chances. A lot of off ramps, and he didn't take them. BLT saying, "Under what?" This is not a dumb question, so don't think it is. Under what conditions can the judge deny the motion? Someone is telling me the judge must allow him to represent himself. No, the judge does not have to. If you don't understand how things are operating in court, and you're going to refuse to cooperate by the rules of court and the rules of procedure, and it's clear you can't do it, then you cannot. The judge doesn't have to let you represent yourself. So think about it. If you were incompetent, or your competency was an issue, you were competent to stand trial, but you weren't able to really follow the rules. Well, then they're not going to let you run around and cause problems in court. Joe Biden's growling. Amyloid levels. Yes, can you imagine the prosecutor while she's having sex? "Oh, geez, oh my, oh yeah, that's it, right there." Half Irish, can the judge change your mind over the weekend? Nope, it's done. Shannon says, "I think it's so disrespectful to the families to allow him to present his case and cross-examine the victims and experts, but hey, his constitutional rights are Sixth Amendment uber alles." Eric Fulham saying, "Wash your penis." Always good advice. And the Fed said the only person who has any chance at representing himself is on civil law, and he isn't dumb enough to represent himself, even though he's a walking encyclopedia. Yeah, even Kurt would tell you he's going to get an attorney. Walter Malone for $4.99 for Super Chat. Thank you. I appreciate it. It's good to see you. I haven't seen you in a little while. Ha ha ha. The judge is explaining why he's right and he objects. This is going to be a circus. Yes. That whole time, she was trying to say, "I agree with you. Here's why." And he just won't let her talk like an idiot. Matthew Rafty saying, "What happens if a pro se defendant is held in contempt? Is an attorney then brought in?" I think that would actually be a separate, because now it's a separate charge and offense. They would have to decide, is he going to represent himself there? I would at least make that argument. The court has to make that decision and that determination again. Memento Mori says, "What's a Moorish sovereign citizen?" Moorish Americans are generally what Black sovereign citizens are. They follow a specific set of rules and beliefs that are different from traditionally white sovereign citizens or Hispanic ones. Generally, it's an exclusive thing to the Black community as far as sovereign citizenry goes. And there are Black people who follow white, like the typical sovereign citizen nonsense, but the Moors are a separate set. You'll see them in court. They wear like fez hats, and they consider themselves Moroccan nationals. Like citizens of Morocco. It's an entirely different thing. Richard B. Short saying the news isn't covering the story because the real criminal, the SUV, is not on trial. Yep, and he keeps getting away with it. Prima Air is saying for $2 for the super chat. Thank you, sir. Okay. Kevin H is saying, is this just him trying to get up by some sort of mistrial? He's not going to be able to. He's kind of toast. The judge has done everything she can to prevent a mistrial from happening, and she'll do everything she can to keep the trial going. So, Raven Hood is saying, why is he not on the stand? Because he's representing himself. He's not giving testimony. Tom Robertson. Thank you, Tom. I don't think I've seen you around before. She has no business being a judge, entertaining all this rehashing of filed and ruled on motions. Yes, but because he's new counsel, she has to go over those things. This is her protecting the record. Spending this 3 hours right here keeps him from trying to raise issues on appeal. So that's why you do this. You spend a little bit of time now to prevent a problem from later, because let's say, God forbid, a court says, actually, you should have done something. New trial. That's a disaster. So she's going to do that and be cautious. It doesn't hurt. Bosif is saying it's bullshit. If you're in America, you should be able to speak English. If you can't, go back home till you learn it. Sure. But what happens if what happens if there's somebody visiting? If they're a tourist? Now, I understand most likely they are somebody who lives in the area, but let's say they were visiting the family. You know, if somebody from France comes by and visits and witnessed it all, are you going to tell them, sorry, you can't testify because you can't speak English? Let's see. Aaron Gogol. Good. I haven't seen you in a while, man. Glad to see you. Is there a difference between legal advice and procedural advice? Yes. There's legal advice. She can't tell him what to do, but she can explain, here's how the court's going to do something. So she's allowed to tell him, I'm not going to do X, Y, and Z, or she can explain what she's going to do. How do you handle this procedure? How do you want me to address X, Y, and Z? That's not out of the rule. That you can tell there's a little bit of difference. She is willing to explain what she will do versus what he needs to do legally to represent himself. AD for $2. Thank you for the super chat. I appreciate your support. We don't drive, Sean. We travel on a magic carpet. Aaron saying, just going back through some of these. Once you're testifying for the state, aren't you more akin to accuser than a victim? Yeah, you're a victim, but you're also an accuser. Yes. Kale Burke saying that's a small court. Believe it or not, most courts, like 50 or so people, is probably the max. I mean, people don't want to sit on top of each other. The Johnny Depp one was a little bigger than normal, but that's kind of standard. Nick, this is a very poignant point. The way this judge has handled herself really emphasizes what a bitch the Alex Jones judge is. 100%. This lady, even when Darrell Brooks is being an asshole and insufferable, she's doing her job like a consummate professional. And that's what she should do. Netflutter, are the prosecutors salivating at him representing himself or dreading it? Look, they've already got it in the bag. They're actually probably dreading this. It's going to be a pain in the ass because now they have to worry about this guy who doesn't follow the rules. They've got to protect their witnesses. They got to protect their victims. And also they have to protect the record. They can't let him do a bunch of goofy crap and then try to bring it up on an appeal. So they've really got to be on guard. So no, I'm sure they would rather he not do this at all. So I'm almost done with these guys. We're catching up in a second here. Richard B. Short for Super Chat for $4.99. Thank you again. Did you ever hear... Oh, I got to do this in the voice of the Emperor. Did you ever hear the tragedy of P. Barnes the Wise? I thought not. It's not a story a Sovsit would tell you. Yes, P. Barnes is a great legend. Thank you for the Super Chat, by the way. Dr. Mimo says, show the pupper. The pupper does not like being picked up. For Brandon Lesko, another Super Chat for $10. Thank you so much for your support. I appreciate it. Wait, is this still going on? Shout out to my student driver at the council table. Oh, funny. Ladybug Lisa for $5. Thank you for the super chat. I appreciate your support. Thank you for answering questions, Pot Crim. It's your new nickname for me. Okay, well, it's better than asshole, I guess. Brandon Lesko for $10. Petition submitted for a smash or pass poll in the judge. Well, I put one up. Let's see where we're at. 135 votes. That's enough. We'll end the poll. Okay, for the judge, it is yes, 84%, no, 15%. Jeez. All right, so that gets rid of all the startup things. Okay. We got to catch up here. How is he going to prepare for court in jail? It's going to be difficult. It is going to be very difficult. Yeah, it's not easy. It is not easy at all. Amanda Moore is saying, do you really think he's a sovereign citizen, or do you think he's being coached? I think he actually believes that nonsense. Oh, Gene, you're taking off. Well, have a nice day. Is it Sean or Sean? I don't know. Why is my hold on, wait, where did my name tag go? What the hell? That's weird. I thought it'd be up. Yeah, there it is. See, okay. Yep, there you go. It's Sean. So, Bocephus, we love our tourists. Yes, we love our Somalis. We love our Muslims. Oh, they're so beautiful. To quote the great Frogman. Did they offer him any kind of plea agreement? There may have been discussions, but nothing officially was placed on the record. But if nothing was requested, then they're probably the plea offers probably plea to the 6 murders and go do life, or plea to a bunch of it. There's not really. These are one of those times where there aren't really any offers that are good. Some of the people are trolling here. Yeah, it happens though. A couple hundred people. Anyways, Robin, thank you for stopping by. Crap, trying to catch up with everybody. Let me see here. Oh, who is the injured party? Kevin H says, yeah, some of the chat people in chat are trolling. Basically everywhere. You have more than 2 people. Yeah, I could see him being just doing this to be difficult for everybody. Who knows? Maybe he really thinks he can turn it around. Autodrome 96 saying, wait, he can appeal? Yes. You always have the right. After this trial is over, if he loses, he has the right to appeal. Everyone has the right to appeal. Now, he's not going to be able to argue ineffective assistance of counsel because he represented himself, but he has the right to appeal. You always have the right to appeal directly. So, Lady Buck Lisa saying, I need that SovSit 101 elevator speech. Judge OnlyFans. Guys, if I missed something earlier, I apologize. I was trying to catch up with all the other comments that I thought were important along with the super chats. Oh yeah, Aaron, I was just saying hello. I hadn't seen you in a while. I wasn't like trying to call you out. Just it's nice to see people. Oh, oh, Melistasi, thank you for covering this trial. You're welcome. Thank you for following this. Yeah, well, I'm glad. Yes, it's Sean most days. Other days, it's Sean in the car. Yeah, if I'm out driving between courts or something, I'll stream, but it'll be me from in the car. Now that you have a physical copy of your JD, are you ethically obligated to stop telling my wife women are legal property, or can I keep lying to her about the law? You're allowed to lie to women. It's okay. Keep lying, brother. Stay strong, King. Keep that crown going. Yes. Oh, they're so good. Oh, they're so sweet. Oh, they're so sweet, not beautiful. I'm sorry. Anyone want to take out Siobhan? I mean, that's not hard. I thought sovereign citizens were Greeks only. I mean, technically, they would have been sovereign citizens, yes. The streams are enjoyable, but the chats make it hilarious. Oh, well, I'm glad. What observers removed from the courtroom? It depends at what stages, but yeah, they're gonna have to deal with it. Or maybe jail food's better than prison food. Y- Most guys, most clients I've ever had coming to a jail is kind of like a field trip from prison, but prison's better. There's far more things you can do. You have more freedom of movement. The food's a little better. The commissary's a lot better. You have more access to things. Jail kind of sucks, at least in the experiences I've been taught. HM Beast. That bee won't call me doctor, so she deserves it. That's right. You are a doctor, King. It says doctor on your degree, just like mine. Yes, guys, if you're here and you're new and you like what you've seen so far, I do a stream every Thursday night at 9:30 p.m. Eastern Standard Time. Kind of recover some of the things that have gone on during the week. This week, this will certainly be one of the things we'll talk about. A couple other things: the FBI raid on the safety deposit box company in LA, or if you watch Letterkenny too much, LI. And what else are we covering? A couple other things. Let me pull it up and see what we got. Uh, oh, it's not on here yet. So we'll come back to that. But we'll be covering stuff tomorrow night. Where are the suspenders? That style was dripping. I didn't have court today. The trial I had was over. I thought it might be 2 days. It only lasted one. So no, I'm in t-shirt and shorts today. Olay. Okay, where are we here? Oh, from Deep Surface, $2 super chat. Thank you so much for your support. I do appreciate it. It's been a fun day so far. The judge is Linda Carter. No lasso required to hit it. Um, you're gonna go catch lawyer live Hurricane Ian stream on Instagram. Yeah, thank you for being here. Yeah, I hope everything's okay for Peter. I think they're down like by Orlando, so they should be okay. My parents are in Naples and they said it was rough on the coast, but everywhere else is safe. So if you know people in down along the Gulf Coast, you know, check in on them. Hope they're all right. Thoughts and prayers for all of them. But it seems like not too much damage yet, at least where they were. So big knock on wood. Okay. Who's the law trooper that resides in Korea? Well, there's two of them. There's Legal Vices, Jeff, and then there's Legal Mites at Andrew. So they're both in Korea. They're actually fairly close to each other. I mean, Korea's not that big to start with, but Naples Fire and Rescue tweeted a fire engine more than halfway sunk in the water. Yeah, there's some low spots, and it probably did, but overall, from what I've heard about from my parents, my sister talked to them, the city is not like destroyed. So at least it's good for now. Ladybug Lisa saying my cousins in Naples, they have damage. I mean, there's some damage, some things have gotten blown over, but it's not like the hurricane just bulldozed everything. Now, up by Punta Gorda and Fort Myers, that's where like the eye and everything hit full speed. So there, it might be a little worse up there. So I know one of our mods, Jim Satala, he's up there, and I hope he's doing okay. Yeah, Naples is experiencing storm surge, but my parents, they were driving around. The airport was underwater. The runway's completely underwater. And so that means most of the airport was underwater, but at least they were able to get all the way up to the airport. And they came in from a little further deep in the city. So, oh, Peter's in Tampa Bay, Clearwater. Oh, they're about to get it. I hope they're okay. I hope they're okay. Tampa Bay, Clearwater. I know where Tampa Bay is. I don't know where Clearwater's at. There was sharks swimming in the streets. Yeah, some of the forecast maps are really bad. So if you guys do know anybody down there, yeah, check in on them if you can. I know my parents, as of minutes ago, or probably about, well, you guys saw me on the phone when it was on mute. They apparently had cell coverage still. They just had to drive around in a car to. They just had to drive around in a car to charge up their cell phones, but they were still able to get out to everybody. So that's the good news. Um, like I said, there's a lot of good news. So hopefully it's kind of one of these ones that turns into being like a mouse fart of a hurricane as far as the damage is concerned. Oh, Clearwater's where the Scientology building's at? Oh my god, I'll have to drive up there the next time I see my parents. So that'll be fun. Is that where I grew up down in Naples? No. No, I grew up on the west side of Cleveland. My parents moved down to Naples like 2009. Yeah, this is not going to be like Hurricane Andrew, hopefully. Oh, so yeah, that is it for Darrell Brooks. They are going to start the case Monday morning, so he's got a couple of days to prepare. I'm not sure what that's going to do for him, but good luck. It's kind of like listening to Star Fox. Good luck. Runkle is causing havoc. What's wrong? Is Runkle on somewhere right now? He was on with Jeff this morning, causing issues. Oh no, he's not on right now. The jail law library must be state of the art. Most of them suck. I know you're probably joking, Alpha, but been in a lot of jails. It's no, not very good. Not very good at all. Oh, the storm named Ian. Yeah, yeah, fair enough. Went right over my head. Sean is kinda I'm not gonna make you laugh, then boom, your screen is boom. Oh. And Wish is saying, appreciate you covering the case. It's incredible. This isn't widely covered yet. Well, remember, the trial hasn't started yet, so that takes I mean, it probably will get more coverage. It's just right now, this is a pretrial hearing. So we'll see. We'll see. But I think there'll be more coverage later. And the Fed saying the storm is named Ian since Ian is an expert at derailing Timcast. The next hurricane will probably be Lofty. Oh, that's a funny one. Funny, funny, funny. Yes, Runkle was on earlier talking about how the Canadians have started repealing restrictions. I mean, it's good they are, but how long is that going to last? That's the thing. So that's my only thought is like, how is that going to work long term? It's it's a big mess. It's 100% a big mess. So we shall see. Hurricane Sean. 1 year that almost happened. Oh gosh, it was one hurricane away, and it was the last one of the season. They got to R, and I was so upset. But there has and then every year they switch up the names, so I think it's gone off the rack for now. But yes, there was potentially going to be a Hurricane Sean. Oh, okay, Ladybug, you don't know what the sovereign citizen stuff is all about. Okay. The sovereign citizens are people who, even if they had no ideology existing to them, they're people who don't think the rules apply to them at all in anything they do. It's not just the law, but they'll do whatever the hell they want on their own. Like they would steal from you, they'll cut in line, they do whatever they want. They don't think any rules apply to them. That is their entire modus operandi. A lot of sovereign citizens are scammers and thieves. Many of them, they don't like the government, but they're on welfare. They fully take advantage of it. They are people who do things like they engage in paper terrorism, meaning they'll file false liens and try to steal land from people. They do any number of things. Sometimes they can be fairly violent. Every once in a while, these are the type of people, if they ran into you with a car, they would probably try to sue you in the car over the car accident, and they certainly wouldn't pay up even if it was their fault. Like I said, they're scammers of the highest order generally, and they're lunatics for the most part. Yes, they're big on squatting. Bocephus says, I admire their stubbornness against the government. Yes, I do. But it's all kind of insanity. Yes, El Nino is Spanish for the Nino. Yes, Trudeau will change the rules the first time someone sneezes. And then, yes, Viva fled to Florida, and already there's a hurricane there. Yes. We got to draw the lines. Got to start connecting them. Connect the dots, guys. Just like Robert Gouvet does on his thing. Start drawing the mind map. Viva moves to Florida, hurricane. And it's on the other side of the state. So isn't that a coincidence? The hurricane missed where you live, Viva. How did you do that? What sort of Canadian sorcery did you do? Are you the reason why it missed? Is there like a Canadian harp? Do you guys control the weather now? How did you do it, Viva? There are answers and people demand to know them. And if I've got to bring it up, then I will. But we're on to you now. Our first Spanish lesson is free, I hope. It's Turdo, yes. Yes, the Robert Barnes is. You're right. Robert Barnes is the weather machine. Viva's just the patsy. Yes, the Hurricane Nameless rotates every 6 years. Yes, it does. Viva has funny hair powers, yes. Harp controls us all. Stabby McStabwood says, why are you describing me? I'm not a sovereign citizen. I'll be right back. There's some land pirates trying to prevent me from traveling in my vessel. You fight the power, brother. Good luck to you. Okay. Well, guys, that is it, I think, for today. It is 5:30. I've got some things I need to do. I got to get a pork roast into the oven, get dinner ready for my better half. I promised her I'd make her something really nice tonight. So I think I'm going to wrap that up. Guys, please like and subscribe if you enjoy what's going on here. If you have a comment or question, please throw it down there below. I'll try to answer them as we get to them. Tomorrow night, 9:30, we'll probably be covering this because there'll probably be some more information in the meantime. But we'll be covering other stuff throughout the week. Alec Baldwin and actually, we'll probably talk about the Nord Stream pipeline. Did the U.S. commit a war crime or a crime against humanity by destroying a gas pipeline in the Baltic Sea? Oh, how close are you following the ATF frame receiver fight? The Northern District of Texas gave another L by saying they couldn't classify. Yeah, I think it's likely going to be unconstitutional, but it's going to take some more ass whooping from the courts. Yeah, I hope it gets crushed, and I saw that, and I might comment on that coming up. But yeah, for right now, that is out there. But yeah, let's hope the courts keep chipping away at it. Eric Fulm says, "Angels don't play on this harp." Hold on. I can't do the Jesse Ventura voice today. Yes. It's a thermite paint. Oh, angels don't play on this harp. Oh. It's a euphemism for sex. A lot of things are euphemism for sex. Oh, okay. Yep. See ya, oh Fox. It was fun trolling. I don't think you guys were trolling. I thought it was pretty good. So you guys have a great night, and I will see you guys tomorrow. And remember, until next time, just because you did it doesn't mean you're guilty. Except Darrell Brooks, you probably are guilty, bro. And yeah, this is gonna be awkward to watch. It's gonna be like watching a suicide.